I think often when we hear about tech and AI in professional settings, a new technology has rolled out and a hospital says, great, we're going to lay off 50% of the radiologists. The radiologists are against it and no one feels good about the system. But here's like the hospital CEO thinking about how to make the hospital like more profitable and has said this. In reality, the better version of this like wonderful technology story is Americans are dying of this awful cancer. Here's an AI that is going to take us from capturing 95% of the tumors to 99% of the tumors. You know, your radiologist is remaining in the loop. That is a
Hmm.
good news story, right? Like that is a tech for good story, but again, that has nothing to do with like the tech itself. It is the youth story, right? Like that is a business decision about how to use the technology.
Welcome to This Is Not Advice, where you'll hear from successful people in different occupations about how they do every aspect of their jobs. I'm Roy Bahat, an MBA professor and a startup investor in the future of work at the venture capital firm Bloomberg Beta. And I want you to be able to learn from the same people who I get to learn from. As usual, this is not advice because the people who we're speaking with have no idea what you should do with your career. They just know their own experiences. For today, I wanted to learn about lawyers and really courtroom lawyers. And I actually want to learn ever since I read this play, Inherit the Wind, which is about the Scopes monkey case, where literally they put Darwinian evolution on trial. And then I met someone whose name kept coming up as an extraordinary litigator, Doha Mekki. Doha was the former acting assistant attorney general in the Department of Justice's antitrust division, where she oversaw more cases about monopolies in her term than the DOJ had filed in the 4 decades before. And so is she the most popular person at the big technology companies? Probably not. But we believe in learning from the widest range of people possible, so long as they are extraordinary at what it is that they do. What I didn't expect is how different the job looks from the inside and how little of it happens in the courtroom. Most of it is years of investigation, of writing, of listening, and doing everything you can to stay out of court. Doha traces her own path to getting there from Sudan to a Southern prep school, through a year teaching history, to discovering while she was working in a hospital that lawyers are actually the hidden hand in how health gets administered, let alone justice. She walks us through how cases really start, how a trial is actually like a morality play, and what it felt like the day that a company walked in with a binder full of documents and proved that her hunch had been right all along. Welcome, and remember, this is not advice. So I think the thing I was saying is just that even when your occupation is talking for a living, which I get that that's only one part of what a lawyer does, it just seems exhausting after a while. Are there times like physically in the legal arc of doing things where it's just like, I'm just beat? Like after, I don't know, are there courtroom days where you spend the whole day in the court? Is that how it works? Or is it more like I pop over for an hour and then I just do something and go back? Like I literally cannot imagine what the day parting looks like.
Yeah. So, when you are fortunate enough to work in the federal government, you have the best job of all lawyers, I think. And, it's the AUSAs who spend time
What's an
like,
AUSA? Just so we.
yeah, it's an assistant United States attorney. So I'm a dork who lives in Washington, DC. And so it's total, we're like living the like acronym, like the soup of it all, but it's the assistant United States attorney. And so they are the people who are hired as lawyers in these 93 federal districts who enforce the federal laws on behalf of, the federal government, and they pop in and out of federal district courts, and they spend the most time in the courtroom of any lawyers. But so much of the regular lawyer's job is, I don't know, it's just like it's desk work. It's negotiating, it's listening, it's doing everything you can to stay out of the courtroom. And so it's really the rare case that lawyers are in court.
Well, I mean, yes and no, I guess. I mean, there's a
Yeah.
lot of like, it's sort of like if two business people are negotiating, by the time they're haggling over some term in a contract, that's actually sort of the last resort, right? You want all the pre work and mutual understanding to reduce the number of things you have to haggle over. And so if lawyers who know what that ultimate conflict looks like in the courtroom might also be the best positioned people to guide their clients about whether in fact to end up in the courtroom. I don't know.
Yeah.
It makes me wonder, like, are there lawyers for whom the most time spent in the courtroom is the thing that they're solving for? Like, I mean, you're a prosecutor. And so as a prosecutor, you're like, no, we need this thing or to go to court versus like, how do you think about whether you want it to go to court or to settle?
Yeah. So I love business settings because often deals are happy
Mm,
occasions, right? Like you have two counterparties that essentially want to get married, right? They want to reach a happy end state, right? Like
right.
that's often like the best place to be, right? In the case of violent crime, right? In the case of someone who really wants their day in court and really wants redress and justice, right? And a neutral arbiter and a judge and a jury of their citizens to hear what happened to them. In that case, maybe you really want it to go to court, right? And you want that airing.
So wait, when that makes total sense, is like you want your justice and the court is the delivery mechanism for justice. But
Yeah.
it makes me think when you work for the government in the kind of role you were in, your client is the government, right? Is that the right way to think about it or no? Who is your, or is your client the people? Who is your client?
I always thought of my client as the people.
Okay. But
And
so then you
that's
want
such a
justice
US
for the
thing.
people, that violence has been committed on the people in the case of economic crimes or something like that.
Yeah, and the US is it's an interesting way of thinking about it. Like that's we're as Americans, power comes from the people. That's our constitutional design. That is not how our counterparts in France or Germany or
Huh.
in Japan might think about things, right? Like
Huh.
we tell the government what its powers are, right? And so I think of myself as a radical constitutionalist. And so, you know, I'm an immigrant. I was not born in this country. I am someone who came here when I was 4. And so I have this intense love affair with this country that took my family in when I was 4. And I was a history teacher before I went to law school. And so I have the highest regard for our constitutional design because I do think it's extraordinary in its protection for regular people. And I don't think we're perfect by any measure, but I do think we live in the best country in the world, and I think it's a lot better than basically everywhere
I
else.
think I hear you, radical constitution means constitution maxing to you.
Yeah, totally, totally, and I think it's a beautiful, wonderful thing that, power lives with the people and that we trust the government to exercise authorities on our behalf and that the government is constrained, right? And so when I was an official in the executive branch, I was mindful of that. I was always thinking about the law as Congress passed it and as the Supreme Court and the courts of appeals interpreted it. And I felt like I couldn't go off and breathe different meaning or goals into statutes, even if I had different ideas about what the law or
Sure.
policy should be.
Sure.
Right? And so that's an extraordinary design. That is not what exists in a lot of other countries. So that's what I mean by being sort of a radical constitutionalist in the way I thought about law.
I love that. Okay. Well, so I want to like, let's start from the top because our goal here is we're going to try to
Yeah.
give people an understanding of how to perform the job of a litigator with the understanding that you've had a very particular career. And we'll talk about some of what came before and during it, So you were talking about being a history teacher. Just tell us about how you chose to become, at what point did you say, enough of this, I'll be in the next history book and go sue some people?
Yeah. Oh boy. So I was a huge dork. And that starts with going to a prep school in the South where I had a great historical education. And I think I had a sense for the soul and spirit of law. Every lawyer
Mm,
is kind of a lay historian, I think. And I think that started in secondary school for me, continued in college. I spent my college summers doing service work because I had a merit scholarship that sort of funded that kind of work. But I was actually interested in health issues. I don't know why. I just kind of
Okay.
thought they were interesting. And so I spent my first summer interested in HIV and AIDS work. And so I spent time at a hospital in North Carolina working in an infectious disease institute with
Okay.
sick kids. And, the lawyers had a really extraordinary role in shaping, the kind of care and delivery of care in that hospital. And so I had a pretty good sense of, the role of lawyers in the administration of justice.
So, okay, so that's not a setting where you typically hear, and that therefore the lawyers were powerful. Like you didn't say, I volunteered in a setting where there were crimes being committed, or in a setting
Right.
where, where the lawyers were negotiating over contracts or something like that. And so, what was it about being in that hospital setting where you saw that?
So, the social workers had a hand in everything. And this particular hospital had a really great like bioethics approach to care. And so you'd have the doctors, the nurses, the bioethicists, the social workers. I spent a day going around with a Catholic social worker who just visited patients at home and made sure that they were eating properly and were taking their medicine. And so it just sort of got a holistic look at like the lives of these people. And, there were opportunities to do research for cases where, maybe people were being mistreated. Maybe people were living, and I want to be careful to, protect confidences from that
Yeah, of course.
time. And
I'm
so,
definitely not trying to go for details.
yeah,
It's
yeah,
more
totally,
what,
totally.
you're staring at this hospital system, and your conclusion
Yeah.
is not that the doctor or the head of the hospital is the person who governs what happens to somebody. It's that the attorney
Totally.
is.
And this also might be like just the peculiarities of my own brain, right? Like,
Sure.
the doctors are extraordinary scientists who, shape the health and well-being of humans. That certainly is not my gift, right? But lawyers also have a hand in shaping the well-being of others and removing children, for example, from abusive homes, right? From certain settings where their health outcomes were going to be made worse because someone was not looking out for their best interest, right? That is an important service that lawyers have a hand in shaping. And so that was the first time I thought about how, even in a hospital setting, even in a care facility, lawyers have a hand in the administration of justice.
And yet you didn't beeline right from there to law school. So just tell us.
No.
So you had this realization, and for me, by the way, like when I was in college, I worked at the student public service organization, and my
Yeah.
conclusion was that the media drove a lot of what we were able to do. And so then
Yeah.
years later, I found myself wanting to work in the media, but it was a circuitous route. And so, yeah, tell us
Totally.
about how that leads through being a history teacher and all that stuff.
Yeah. I spent my next summer doing sort of the same thing, but in Uganda, right? And like helped this like little HIV AIDS clinic lawyer incorporate the clinic because it turns out when you incorporate, there are lots of ways that you can accept money differently, right? Like it shapes the way you allocate capital and can fundraise. And that's really an important service, especially when you're doing things like, pharmaceutical trials, right? And accepting donations from the United Nations. And again, doing important work that helps you better administer justice. And so, again, here's this important touch point that lawyers can have a hand in better administering justice. By the time I finished college, I just was tired, right? I was a little burnt out. I thought, maybe I want to go to grad school. I'm not totally sure exactly what the path would be. And so I actually went back to the school that I attended and taught history for a year, which is kind of a gnarly experience, right? Going
Wait,
back,
yeah, you went back to your
become
own
colleagues
school.
where I went there for almost a decade, which is a little odd.
Uh-huh.
It's weird calling your former teachers by their first name and being colleagues with that. Like I'm from the South. Like I don't know, it's weird.
Yeah, right. Like you were in a respect relationship, and not that it's not respectful to be a co-teacher with somebody, but the respect relationship that is unambiguous becomes more of a peer relationship, you know?
Exactly,
Yeah.
exactly. But it was very good for me. It's very good for me, right? Teaching actually is very good practice for becoming a
Hmm.
lawyer because you need to break down ideas very, very clearly. And
Hmm.
teaching upper schoolers, right, 10th graders and 11th graders, world and United States history is so fun because they are so smart and they have ideas about the world, right? They're curious, they're discovering the world, they're pushing back, they have their own viewpoint, and that challenge, the back and forth, it's so cool. It's so
So I
cool.
know one of the things when we were like communicating beforehand about this is I asked you about, the works that influenced you. And you talked about one that is from like the late 19th century about a company about Standard Oil. So I don't think about that as a text that would get taught typically in high school history classes. So maybe like, were you already laying seeds for becoming an antitrust lawyer, or how did that unfold?
Yeah, I mean, we'll get to this, but I didn't think I would like antitrust because it turns
Hmm.
out, my first antitrust assignment I actually hated, but the soul and kind of spirit of, the robber barons and the Gilded Age, I loved. I loved. And I really like American business history.
Huh.
And I love teaching this era. And so, Lloyd writes this very long piece in the Atlantic about the tyranny of life under Rockefeller's, Standard Oil Trust. And the reason I like it so much is because I think he does a better job of teaching the story, right? Everybody learns about how he buys up all the oil refineries, and anybody who doesn't do business with Rockefeller either gets, elbowed out of business or shut down. But it's actually by collusion with the railroads that he
Hmm.
really makes a go of his monopoly, or his trust. And I just think the richness of the story of the unfairness of life in this system and the ways that the rich sort of have this two-tiered system of justice that they perpetuate on the rest of the country is fascinating. And when you ask kids about this, they do have a sense of what is right and what is wrong, and eliciting their ideas about the world as it should be and the world as it existed back then is it's fascinating.
How did you decide on the timing of then, you're talking about these themes in the classroom. It was not about what you having some, grand design for what your legal career would be. Yet at some point, I don't know if you thought of going to be a teacher as something that was a temporary tour of duty or in some other way, but at some point the spark happens and you go pursue more schooling. Or was there something in between?
No, I knew it would be short term, and so I was applying to law school at this
Got it.
point and knew I'd be going off to law school, but I went to law school not knowing what kind of lawyer
Well, and you
I
also
was gonna
studied
be.
bioethics at the same time. Did I make that up?
I did, I got a concurrent degree in bioethics. Law school, I love so I went to Penn Law, I loved Penn Law, I had amazing professors, but law school teaches you in this very specific way, and it can kind of break down the way that you think, right? And that's kind of the point, right? Like you sort of get broken down, like built up as a lawyer, but you need to exercise a different part of your brain. And I do find that having just another sort of doctrinal approach can be really
Got it.
useful.
So it just sort of helped you to be thinking a little bit differently than all the other lawyers were thinking. By the way,
Totally.
this woman who I debated against in high school, who was like definitely a fearsome debater who we feared, ended up becoming a bioethicist. So I always feel, because of that association, a little intimidated by bioethicists,
I did spend a lot of time reading Kant and the moral imperative during my first year of bioethics. And
as
so
one
I don't
does.
know.
There's a common intellectual lineage, and it seems like you were not common. There are shared intellectual precursors for both modern law and modern ethics, but it does
Totally.
seem like at least part of what drove you is the world of ideas. I mean, somebody could say, I wanted to be a litigator because I liked arguing with people, and or I liked, any of the other valid aspects of, I liked, being the champion of the little, like, the powerless person, which is, I think, imbued in some of what you're saying. But it does seem like there was an intellectual strain to it too. Does it feel that way to you?
I think it was more intellectual. And I should
Uh-huh.
say, I mean, now I certainly have a view of what I think law should do and the idea of fairness and fair dealing in the marketplace. But I don't think I had a moral view of business law
Mhm.
or
Sure,
antitrust
sure.
theory at this point, right?
Yeah.
Like this was a very nerdy pursuit.
Yeah, but okay, let me ask one other aspect of the career choice, which is, you are an immigrant yourself. I'm a child of
Yeah.
immigrants. I think each of us had a parent who was involved in architecture at one point or another.
Yeah.
And so, like, I
It's
can
fun.
imagine some aspects of what the family environment might have been, some aspects. you know, we often talk about this with entrepreneurs where sometimes they have to overcome the mom and dad problem. Usually it's the mom problem of like, my mom won't be proud of me if I'm an entrepreneur and none of her friends have heard of the place where I work. Yet I feel like being a lawyer is one of these occupations that in many immigrant communities, certainly I'll speak to my own, it's like everybody gets it. Person's a lawyer. A lawyer for the government, it's like the most stable job ever. And so I guess I'm curious when you thought about your career choices after working so hard, getting into great schools, having summer experiences, blah, blah, blah. To what extent does the family environment or culture, if that's the right way to put it, or however you thought about it, to what extent did that factor into how you thought about your occupational choice?
Oh, it's brutal. The way being an immigrant operates on you is tough.
Yeah. And unspoken sometimes, right? It operates in the background. What a plausible story that, we all make these choices, yet it's sitting right there.
Totally, totally, and the weight of it, right? I mean, I was born in Sudan. Like, I don't where are your parents from?
Oh, from Israel.
Okay, so, like, when your family comes over and, like, makes the investment in, like, starting over and, like, starting anew, there's just so many, like, unstated ways that, like, it just operates on you, and you're always thinking, "Is it worth it? Am I worth it?" But I was really lucky because I have parents who are supportive, and I think even if I had been, I don't know, something not, like, super prestigious in any normative sense, I think they would have just pushed me to be, like, really exceptional at that.
No, sort of excellence for excellence sake. I remember our
I think
first
that's
our
right.
first guest on this podcast was a scientist, and I went to his party when he got tenure. And oh man, I'm going to out him, and his whole family's going to be so mad at me for this. But his mom stood up at the tenure party, and she's like, "Good job getting tenure. Next stop, Nobel Prize." And I was like, "It never stops. They never stop. Nobel Prize. You want to get sainted? You get
Yeah,
sainted. I want immortality." And
totally.
at least for me, the way I thought about it, so like I said, my parents were Israeli. They came to the US. They didn't have anything in terms of material life, but they didn't think of it as we started over and started from nothing. They thought of it
Mm,
as we're going for bigger opportunities, and they were supported by a thick community of others who wanted to be there for them. And I guess my
yeah,
experience of some of the immigrant kind of duality is, on the one hand, there's this push for excellence. And on the other hand, there's this push, not on the other hand, integrated with that and sometimes conflicting is a push for safety of like, do something where you're going to be okay. And one of the
yeah,
things that I hear in your story is a sense of, I'm going to want to call it play because, you're talking about serious things, but at least of spontaneity of following some interest, some curiosity. And so I guess I'm curious, how did all those factors play together for you? And, I know we're spending a bunch of time on how you chose to become a lawyer, but
no, I think it matters hugely, and I think your the podcast is called "This Is Not Advice," but
you can. I'm not giving anybody advice, but you can do whatever you want.
yeah, I mean, for the folks who are thinking about, you know, do I wanna be a lawyer? I mean, I think a lot of my life was shaped by my mom's experience. I mean, my mom is a brilliant woman. I mean, she is so brilliant, and, we came to this country in part because, she came from a very elite family. I mean, my grandfather was an ambassador and his father helped fund these like labor unions in Sudan, and his father was a total magnate, and all these like patriarchs in my family also shaped a lot of how I thought about success and a life worth living. And my mom, wanted to be an architect, wanted to get her doctorate, And it was right as Sudan was in transition. And, there was this awful, awful period where there was both the rise of the Muslim Brotherhood and also a military regime and sort of a consolidation of power and a very sort of unstable, we'll say an unholy alliance between them. And then, the bloodless coup that brought in Omar Bashir. But it was also a deeply misogynistic regime that was antagonistic to women. And so her experience got progressively worse. And so she needed to pursue education. And so she came here with the intention of getting her degree. And then her scholarship was withdrawn. And
Mm.
so, her opportunities were
I'm sorry,
clipped.
scholarship from whom was withdrawn? The government was
She
giving
had a
her
government scholarship
to come study here.
to come study here and it was withdrawn.
Wow.
Right. And so her opportunities were clipped. And so I have had an extraordinary set of opportunities in the shadow of, this brilliant woman's life being shaped by this horrible regime. And I have had every opportunity for no reason other than the incredible generosity of the US government and the American people.
I mean, look, of course, the deep love for a country that did that for you is extremely understandable. I think what I hear you describing is a big status shift you go from being a high status family to coming to the US. And I'm curious if any of your experiences with, the justice system as we have it were driven by things you saw. Like, did the system treat you well? Did you feel like there were tears? The American promise, I feel like, is supposed to be one of universalism, of no matter who you are, the system will treat you with fairness. We all know that in reality, that's not how it operates. And so I'm just curious what your experiences were with that.
Yeah, I have been extraordinarily fortunate. You know, everyone has frictions that they experience in
Yeah.
life, some of us more than others, of course. But I think it does shape our sense of what justice is supposed to look like. My interest has been in public economic law. I have views about what full participation our public requires. I do think it requires robust social, political, and economic rights for all. I don't think that we have been as enthusiastic about the economic content of that participation, right? Like I was a appointee in a Democratic administration, and I think Democrats in particular, we have been very good about championing civil rights and certain social and political rights, but really filling out like what robust economic rights are. There's a vacuousness to that, and I think we can be doing a better job, and that's what I've devoted my life to doing.
Let me fast forward because we'll go back to like how you train once you become a lawyer and what the experience of school is like and all that. But I want to get to like, when did you feel like, okay, I'm a lawyer now. I can do my stuff. Like, and I don't know what the end to end thing includes. My naive look at it was that what it includes in the first instance when you're a fully fledged lawyer is picking what cases to work on. So I was going to suggest we start there, but I'm not sure if that's right. But even before we do that, I guess the question is, when did you feel like I made it? I'm a lawyer. Or
I
do you feel that way yet?
I would be curious if any lawyer ever feels that way. Like, there's a reason it's
Wow.
called
Well,
the
look, let me
practice
just
of
say,
law.
I think that's a matter of personality in the sense that I know some people who felt like they were lawyers and then they were teenagers. And like, just like hand me the certificate so I can go do that thing. And I do think, by the way, I think that's a really important point, which is, we could discuss when objectively, like if I asked you a slightly different question, which is when do you feel when you hire someone, they are trained up to be able to operate independently as a lawyer? My guess is you could give a crisp experiences and capabilities based answer. But then when I
Totally.
ask you that question, and objectively speaking, you have had a storied career, literally storied, as an attorney, you know, the feeling is different. So, I guess what's in there for you? I mean, another way of asking that is, what would you need to be able to do or feel to feel like a fully fledged lawyer?
Look, there's a lot of judgment that you need to build up to be an experienced lawyer. I love antitrust law. It's what I've practiced for 15 years or so. I fell into it. Antitrust is civil, it's criminal. It's almost always bet the firm. I would not want to hire someone who is a little iffy about being an antitrust lawyer about an antitrust problem
Sure.
because it's bet the firm. Now, after having led one of the major institutions of antitrust, I feel like a fully formed lawyer, but it's one you feel like you can see around corners and
Mm.
reasonably anticipate issues that I think you can call yourself, a fully formed lawyer, right? And you can tell someone, "Hey, if you pull this lever, this thing is going to move in the back of the room. Don't do that." Right? Or do it this way,
So there's sort
right?
of a sense of how the unseen systems work. Is that what you mean? And
I think that's right.
yeah, I mean,
I think
I
that's right.
definitely see that with entrepreneurship and venture capital and some of the other domains, that I've worked, government, et cetera. I remember when I was in government, we had this moment where I worked for the city government of New York and we were working, we thought collaboratively. The federal government had allocated money between the city and state of New York to recover from 9/11, and it was $20 billion dollars in total. Maybe I'm not getting the number quite right. And let's say it was 10 and 10, the city and the state. And we thought the way it should work is like public policy. We all work for the people. Let's go talk to our counterparts in the state government and say, here is what we think a $20 billion plan should look like. What do you think a $20 billion plan should look like? And let's figure it out together. And the guy said, wait, which end is this coming out of? Our end or yours? It's like, wait a minute, shouldn't we all try to work together? And the guy said to me, he's like, this isn't McKinsey. This isn't Harvard. This is politics. First of all, it's like, I'm flattered you know my bio. My boss like literally stood up. It's kind of legendary. Dan Doctoroff. He stood up. He goes, I resent that, and walked out of the room. I was like, if anybody ever attacks my people, I want to do what my boss just did. But, there was something to it where I realized in a moment that there was a game operating that was, of course, I was embarrassed because some part of me knew it, that there's a game operating behind the game. And, it's sort of like if you take the rules at face value, sometimes they work and sometimes they don't. Actually, maybe before we get into picking cases, if a lawyer is earnest and is like, I'm just going to go before the judge and make my argument, and like, what are the important dynamics of being a lawyer where you need to be able to see how the subtext or the actual game is played, not the notional game that people think they're playing?
Oh, yeah. Before you make an argument, you have to have thought through, sort of have sat in everyone's chair and thought about what are the forces operating on them before you make that argument, and what are the like pros and cons of deciding for you and against you for all of those
Mm.
actors. And again, those are things that come with judgment. And I would also note that, very few antitrust cases are sort of a solo practitioner game.
Mm.
Like it is kind of a team sport.
Our guest who was talking about being an ER doctor before the pit, I don't know that we understood the team sportiness of it, but it was a very vivid story. So yeah, tell us more about the set of stories for an antitrust litigator.
Yeah, totally. So when I was first starting out, the first matter that I worked on was the proposed merger of AT&T and T-Mobile. It was a failed merger, but those are huge teams working on that case. That started off as like a small group of people before it kind of mushroomed out. But even then, the sort of diligence teams, the small group of people thinking through, is this a good idea? You need folks who have different sets of expertise and competencies, right? Who is going to be your antitrust specialist? Who is going to be your FCC specialist? Who is
Mm.
thinking about the arguments to the agency? Who is
So
going
it's an
to
Avengers kind of
prepare the
situation where
board?
each person has
Yeah,
their special role. It's not like a team in the way a sports team is a team. Obviously, sports teams have different roles, but it's more like an Ocean's 11 kind of situation.
totally, totally. And then even when I went to the government, you know, when you first get a file in for a merger, or, maybe it's a conspiracy or it's a criminal matter, right? A grand jury, like something that looks like it's headed towards a grand jury investigation just opened. Maybe you have just a prosecutor and an FBI agent or something, but You typically want a couple of people looking at something because the basic premise is that two reasonably intelligent lawyers or professionals might look at the same facts and come to different conclusions about what they mean. And for the government, that is incredibly important, especially when you're thinking about someone's liberty interest, right? In the criminal cases, right? And so team sports, team dynamics, right? And again, I don't want to reduce government prosecution to the analogy of like a sport, especially when you're thinking about the liberty interest of Americans. It is very important to have different competencies and judgment and lived experiences brought to bear on a file because you'll get better outcomes and you can often kind of straw man and steel man facts and get better judgments rendered on what facts mean.
Okay, so that now I have some feel for the composition of team, for the system as it actually operates. But you're sitting there and you've got some resources. You work for the government, you work for a law firm, and you have some discretion over how to apply those resources. And I notice, like when I watch Billions, a lot of what they talk about with that prosecutor doing, different role, of course, is figuring out which cases are worth putting their limited resources toward. So now I'm going to start like the snout to tail process of a case, let's say. And maybe that's not the
Yeah.
right way to think about it. You can tell me, no, 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 that's not where it starts. But assuming a case is the right place to start, where does it start? How do you pick?
So you just put a finger in like the epicenter of one of the biggest questions
Okay.
that we've dealt with during the 10 years that I spent at DOJ in the antitrust division. So there has been a criticism of certain parts of the federal government, certainly at the DOJ, but other parts of the federal government that prosecute, like the SEC, for example,
Mm-hmm.
that they have focused on small time fraudsters, right? And ignored some of the biggest market moving, impactful problems, right? That sort of pervade our market economy. And so, I came in as the number two with the antitrust division in 2021. And this was after having served as a counsel to Donald Trump's first head of the antitrust division, which was really fun. Worked for a guy named Baker Delrahim. And so, again, this was cool having worked for both Republicans and Democrats, right? And so saw sort of an interesting set of decision makers with different worldviews and different philosophies about how best to administer the antitrust laws. And when Jonathan Cantor and I had a chance to lead the antitrust division, it was our view that our limited resources were best put to work focusing on the biggest, most intractable problems in our market economy. And the reason for that was because we thought ordinary people could not easily sort of fight back against big problems of unfair dealing, abuses of monopoly power. And because both of us had been in private practice, both of us had talked confidentially to a lot of companies of all sizes, startups, sponsors, PEs, the Fortune 100, companies of all sizes, we knew even they were very unhappy about certain bullies in the marketplace that they viewed as, imposing sort of private monopolies, a private system of taxation that was democratically unaccountable,
Mm. And so let me
right?
make sure I understand. Your client is the people, broadly speaking, but the people don't have a uniform interest. There are different constituencies, of course. And I think what I hear you saying is because you had spent time in what only people in government call the private sector, and because of the nature of how you did your work, you were speaking with companies that were themselves, I don't know if the right word is victims, but victims of economic dynamics that were potentially illegal.
Absolutely.
Yeah.
Absolutely. And we also did listening sessions early in our tenure in different sectors. And so anybody who wanted to speak to the federal government, the antitrust division or the FTC about, there's merger guidelines. Essentially, there was a rubric for how the government evaluates mergers. We underwent a process for updating them. And as part of this, there were listening sessions. And so we heard from farmers, we heard from nurses, we heard from people in the entertainment industry. We heard from all manner of people who just told us about their experiences in the marketplace.
And it seems like it turns into a we at that point too.
Yeah.
But I'm curious, just to try to understand what made it a we at that point. Tell
Yeah.
us about Jonathan and tell us about the team of you and Jonathan.
Yeah. We had a great, so Jonathan was the Senate confirmed assistant attorney general in charge of the antitrust division.
Okay.
Right. So he was tasked with the administration of the federal antitrust laws at the Justice Department. I came in as the number two. This was unusual because I had been at the Justice Department for many years and I had just been a counsel to his Republican predecessor. And then we had a lineup of deputies who were exceptional. And then we had counsel, and we also were working side by side with the Federal Trade Commission, then led by Chair Lena Khan and a set of her appointees. But we also had, the National Economic Council, led by a guy named Brian Deese. We had support in the Consumer Financial Protection Bureau, just a set of different people across the federal government in the Biden administration who were interested in reprising the role of a robust economic policy that supported workers, consumers in the marketplace, and again, reprising this role of economic liberty and economic opportunity in a way that we had not seen in a very long time from Democratic administrations. And so that is the we.
Okay. And so then you've got the principle, which is you want, with your limited time and limited resources, to go after the absolute highest impact cases. And one of the things that I know you recommend folks read is this like classic text about the federal prosecutor that speaks to
Yeah,
picking cases, not enemies, basically. Don't go after a person.
totally.
And it
Absolutely.
was government versus Google, not government versus the founders of or Sundar or whoever it was. And so I guess I'm curious, within that, okay, then you have a lot of choices about who to go after. How did you choose who to go after? And by the way, like,
Yeah.
I'm just going to set aside the complexity for many of my friends in tech about who you chose to go after, but more just getting
Yeah.
in your head as a litigator and as a representative of the government. How did you choose who to go after?
Yeah. So again, thinking about most intractable, biggest problems in antitrust,
Hmm.
then there's the sort of constellation of the evidence, right? So you can't emote a problem.
Right. You have a theory and you're going to check. Actually, it's very scientisty in that way.
Totally. And again, having started my career working at a firm where there was very good antitrust lawyers,
Hmm.
the practice there actually trained me very well for government because, I worked for a guy who used to say, "Look, we have a really good story about why we want to do this transaction or why this thing is not a problem or why what they're doing is a problem. We need to go in and tell it." And so our philosophy was we will never be afraid of the truth. And so we need to talk to people and we need to hear everything, even if data gets noisy, even if evidence gets messy, right? We need to be able to find truth in messy facts. And even if they're, facts that cut a different way in an otherwise like trend line that points to a problem, that is okay because we need to be good at what we do and we need to be put to our proof. And we also felt like we couldn't be afraid of an adversarial system, right? Defendants have arguments, and it's a wonderful thing, right? For
Got
the
it.
government to be put to its proof.
And so, did you have moments where you, as you were exploring these things, you were like, this is going to work out. And then you think to yourself, oh, wait, actually, we were wrong. The company seems to have done no wrong here, or something like that.
It happens all the time,
Yeah.
all the time. You think there's something there, there's a lot of smoke, and then you're like, this might be an issue. I can't prove it. And that's life in the big city.
And so, wait, but so how does it? So, okay, so of course, on the yes no question, the answer is yes. But give us a feel for the tradecraft of that. It's like, I want to pursue this project. It could be you get excited about it, you get some evidence. I mean, this is actually a lot like an entrepreneur's journey. I've got this
Yeah.
thing, I want to chase it down. And then, wait a minute, the customer doesn't have that need. So how early do you recognize it? When do you make that judgment call? Like, tell us a little bit about the trade craft. How
Yeah.
do you make the call about when it's time to stop doing work?
Yeah. So I think that prosecutors have to be mindful of what happens on your watch. And in antitrust, you have to be responsive to the markets themselves. And so, in a particular year or a particular moment, there might be a crisis in a particular sector, right? And so sometimes things bubble up, sometimes things are like a little bit frothy. And you might say, maybe I want to send an agent to look at this particular sector, or maybe I want this person to do a little bit of work here. And then I want them to, go talk to a manager, right? Like the chief in the section and make a go, no go decision. Maybe the answer is not right now, right? Like, you don't wanna
And so then
close
you
it.
track it. I mean, we also do
Then you just
that, by the way.
track
There's
it.
like a watch,
Yeah.
track, hold category. And so how do you do that though? Like, it requires proactive effort to investigate
Yeah,
something. And so how do you
totally.
passively remain aware?
You can check in on sources. You can
Uh-huh.
say, "Hey, what happened to this
Like a
bid 2 months
journalist.
later?" Totally, totally, right? There's a huge bid that happened, this company won in 2 months. What happened to the prices? What happened to the quality of this product? Are they still competing vigorously? What happened to the wages of these workers after the merger went through? Did this product actually go to market? Are these companies competing vigorously?
Okay, and so now let's talk about the success case. You keep going, or you find something comes to life. Are there threshold moments where you sort of say, okay, now we're going to file, or now we're going to, I don't even know, we're going to inform the company they are under investigation? What are the moments where you have to cross one Rubicon or another? I guess there are not multiple Rubicons, but you know what I mean.
Yeah. So, look, antitrust is a few different things. When you're in a merger setting, you're making predictions about the future, and that's inherently difficult. And you're engaging with companies a lot in the process. You have a tight timeline. And so that is a fairly familiar process. And you either agree or disagree, right? But 95 plus percent of all mergers go through without a hitch, right? Without so much as a question from the federal government. That was true under the
Yep.
Biden administration. That was
Yeah.
true before.
Sure. Sure.
In the conspiracy cartel world, in the monopolization world, you're issuing subpoenas. You talk to the entire market, right? You have probably done hundreds of interviews, right? You talk to everyone. You subpoena documents. You've taken tons of depositions. A deposition means that you have issued legal process to someone at a company or the company itself. And the prosecutor will either fly out with a reporter to actually like ask them questions under oath, which means under penalty of perjury, right? If you lie, it's a crime. Or, the company will actually be subpoenaed to sit for a deposition. And so that just means the company makes a decision about who is best suited to answer questions on behalf of the company. And so the government by that point has learned a lot, right? A lot of information. And there's actually an information asymmetry
Hmm.
between what the defendant knows and what the government knows,
Meaning the
right?
defendant knows more, but the defendant doesn't know what the government knows of the things that they know.
The defendant likely knows the most about their own products and
Sure.
services and what's
Sure.
going on in the market, but they don't know what everyone else has said to the government about their products and services. And so by that point, the government is starting to put together a memo. And I thought this was really fun when I was in government, right? Starting to put together a memo that summarizes the facts based on, by that point, millions of records, right? Documents, probably thousands of pages of deposition transcripts to answer a single question. Does company X have a monopoly in this market? Did Roy conspire with Lori, right, to fix the prices of microphones?
Hmm.
Right? Sometimes they're hundreds of pages. And then you engage with the companies, and that can be intense, but it's always worthwhile. because you learn things. And it's important to confront companies with the concerns that you have. You often learn things about their defenses, right? They might say, look, they did talk to each other about fixing prices, but they were actually talking to the government. And so it was immunized or something. And so it's valuable, that exchange.
That makes complete sense. Okay, so then I guess the dynamic I hear you describing is you're getting more information from them by engaging them in this process of deposition, but that requires some exchange where they're finding out things that you know, you've done your prep work, they presumably know more. And so maybe it's time for us to go a little bit now. Like at this point, the line between deciding to work on a case and working on a case feels like it's blurry, meaning like you are already working on the case while you are deciding, like at this point, you haven't committed to suing them, for
No,
example.
no, you're not committed to suing at all. And in fact, it's very important that the decision maker, I think, keeps an open mind about, what they're hearing. But no doubt, I mean, you are working on the case. By this point, you are probably years into an investigation. So you
Oh,
have
wow.
committed resources into, whatever it is you're working on. And so it has to be worth it. It has
Right,
to
of
be worth
course.
it. Either the dollar volume of commerce is substantial, right? You're talking about a product that most Americans use. You're talking about something that's really important to the US economy. You're talking about something that's going to have a future impact on, the health of the US economy. I mean, it has to really matter,
That makes
you
sense.
know?
That makes complete sense. And, but then it seems like there's always these considerations. I mean, back to what is on the tin versus what's implicit. Here's one I can imagine. You can tell me if this is a consideration. There's the things you believe are important versus whether you think you can win. And
Yeah.
is that a big dynamic? What are the big dynamics that tend to come up then? Are you really just trying to figure out whether you can win? Are you really collecting the material that helps you clinch the win you think you're going to have or raise the odds? Like what are the trade-offs during that part of the process?
Yeah. The thing you've just described is litigation risk. And look, there's never been an easy antitrust case in the history of antitrust. It's difficult. And no one goes to trial unless they think there's a reasonable chance they're going to win. And so, where a decision maker, which is to say, a presidentially nominated, Senate confirmed head of the antitrust division, where they set that risk could be a political judgment. It could be their legal judgment. It could be a policy judgment, but it's their judgment ultimately, right? Like that's the
What
prerogative.
does a political judgment mean in that context? Because somebody's not running for office exactly.
No, 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 no. But if there's a moment in time when there has been like an atrophying of the law, right? Which is certainly something that we saw in the early days of the Biden administration, where there had been, at best, one merger challenge a year over at the DOJ relative to like the high watermark of enforcement, right? Like,
Hmm.
remember prior heads of the antitrust division, Thurman Arnold, right? Robert Jackson, right? The great prosecutor at Nuremberg, were filing hundreds of cases a year, right?
Mm.
And the down reading of the law and the downgrading of the law are extraordinary, right? And I think both Jonathan Cantor and others have commented on this extensively. Filing 5 cases a year might seem like a lot, but it's still nothing relative to where certainly the 1890 Congress had thought, antitrust enforcement would have
And
been.
why is that? Do you think that's because we've become more cautious? Is it because companies have become better defended, so it takes more resources to go after them? Like, what are the drivers of that shift?
Well, we've had a change in how we interpret the antitrust laws.
So some of it is
There's a
culture or like
shift.
the organizational perspective around these things.
Well, I mean, I think starting in the 1980s, I mean, there was a true shift in how the antitrust laws were
Right.
interpreted. And so there was a down reading of the law, not by any act of Congress, but sort of a requirement that there be more evidence, more certainty. higher standards for harm. And so antitrust sort of moved from being, a risk assessment exercise to more of a requirement that a business actually have harmed a more circumscribed set of actors in a market, a more tightly defined market in many cases. And so I think the cases became harder to win. And I also think as the federal government receded from enforcement, more private cases were brought. Sometimes those cases were not constructed in ways that were designed to win. They were optimized for, damages for harmed consumers or harmed businesses. And so there was the creation of bad law, and so
Hmm.
the system sort of went off the rails over the course of, 50 years or so. Those are the circumstances that we have now. And so new leaders have to operate within that environment,
Got
which
it.
is a challenge.
Okay. So let's now like kind of try to shift a little more fully and put our feet in the case is happening. You are in it. And just taking a note or two on some of what the readings that you had recommended had said, but a lot of it doesn't go into, I guess, case building is the phrase, and that's something you're involved in now. Like, what does a built case look like?
Yeah. We spent a lot of time on this as well when we were in office. And you can imagine that's really difficult when there's been a period of relatively few examples of great antitrust trials. Again, in the monopolization space, there was a yawning gap between the legendary Microsoft antitrust trial and United States versus Google,
And
for
sorry, the
example.
legendary Microsoft antitrust trial, I will submit, is legendary to several of us who follow the technology industry. But,
Yes.
if Game of Thrones is legendary or Taylor Swift is legendary, I will say it is legendary in 6-point font to the perhaps
Yes,
listener to
totally.
this podcast. So tell us a bit about that. And I worked with Joel Klein, who was, the
Yeah.
prosecutor, I believe, at that time. And so,
Yep.
but tell us a little bit about this legend.
Yeah. So in 1998, the DOJ filed a monopolization case against Microsoft. And so if you can imagine the state of technology way back in 1998, this was a case about Microsoft's operating system and its, Internet Explorer browser and whether it was tying its like browsers to this operating system and notwithstanding, again, the state of technology at the time and like the level of understanding of how technology might disintermediate certain paradigms, the complaint was actually quite good and the trial was quite good at describing how nascent and nimble upstarts might use smaller, less like expansive technologies to disintermediate, certain platforms. And that this would be a really important form of innovation that, entrenched incumbents, monopolists would really fear. And this is really, really important for antitrust enforcers because the Microsoft principle really forms the backbone of a lot of antitrust cases that we filed when we were in office, including the Google search monopolization case and later cases. But again, 1998 is when that case was filed. And then a Google search monopolization case was filed in October 2020. That's a long time,
Wow.
right? The
That's a
gap.
long time. Okay. So yeah, so talk to us about then the built case. What does that built case
Yeah.
look?
So this is the most fun thing about being a lawyer. And I have to give a huge shout out to our litigation deputy, a woman named Hetal Doshi, who is truly the master storyteller.
Mm.
We had a saying that all litigation, especially in trial courts, is a morality play. I think
Mm.
that's
What's a
true.
morality play? I mean, I think I know what a morality play is. It's a story about
Yeah.
morality, but I'm not quite sure if I know that that's what it
It is
means.
totally about right and wrong. Like when you are having fights about what evidence means, you're appealing to these high minded arguments in conference rooms right? Like you're deploying sophisticated economic analyses, you are bringing in fancy executives. I mean, you are appealing to these like one percenter arguments, right? To try to narrow the surface area of disagreement. Antitrust, which in some ways is like the most elite, right? Like subset of legal specialties. But in a courtroom, right, especially in a case that's being tried to a judge and even more so in front of a jury, it is about right and wrong, right? You are telling a story, if you're a plaintiff, right, especially the government, you are wearing the white hat. You're
Mm.
wrapping yourself up in the flag. You are convincing, you are doing your best to convince anyway, the fact finder that you have justly used the power entrusted to you and have identified someone with extraordinary power that has abused that power, and you are systematically telling the story. And again, this is just an antitrust, the story of how they amassed it, lawfully or not, but certainly how they have abused it. Right. And you're telling that story in painstaking detail. And there's different techniques to do it.
Okay, so now you've described what the archetype of story is. It's a good versus evil story. And you've
Yeah.
described what it may look like finished, but what are the elements of that story? I mean, like, is it statistics? Is it a victim? Is it, I mean, you called an economist as your first witness in the Gould case.
Yeah.
But, it's like when I think about morality plays, I don't typically think of the opening of the morality play starting with an economist, as persuasive as Susan Athey is. But tell us a little bit about what are elements of said morality play that you are building when you are case building?
Yeah. And I should say the other side doesn't have to be evil for you to be good. You
Okay,
just have
fair
to
enough.
be better. Right. And I've actually never thought any of our defendants were evil for what that's worth. And I should say my
Mm,
general opinion is that I think America should be a cradle of innovation and that American business is awesome. And I think, frankly, competition makes us better.
yeah, but it is a case where you are, unlike, let's say, a prosecutor doing violent crime, where the person
Correct.
who murdered somebody has a moral charge. The moral charge for a big company that has competed aggressively, it's a different kind of morality play. So it's very helpful to say
Exactly.
it's not good and evil. It's good actors trying to do different things. Or how do you think of it?
Yeah. In the case of a monopoly, and again, it depends on the precise contours of the conduct, right, that's being alleged. You are trying to talk about what happens in the absence of fair dealing, right? And so you were telling stories about what happens when people are not treated appropriately and fairly in the market, when their livelihood is threatened. The Live Nation trial is happening right now in the Southern District of New York.
Live Nation is a concert
Yeah, so this is Ticketmaster.
ticket master.
So one of the monopolization cases that we filed during our term was against Ticketmaster. A lot of people have complaints about
I
Ticketmaster.
know. I wish the Taylor Swift tickets were more available. Prices are high.
And so one of the the theme that pervades that story is that there was a lot of retaliation, right? The theory of the case is that Live Nation owns and controls the artist, the promotion, the venues where these concerts and live music are being played, and that it owns and controls the ticketing, and that it has this flywheel and it uses its ownership and domination of every part of that flywheel to essentially lock down other parts of the ecosystem. And so it's like whack a mole, right? If you try to tamp down its ownership and control of one part, it'll simply exercise control over another choke point. And the retaliation is a theme throughout the case. And so one by one, you see the plaintiffs putting on witnesses and examining documents about their fear of getting sideways with Live Nation, right? And they're asking questions about what it looks like and what it sounds like and what it feels like to be terrified to say no to Live Nation,
Hmm.
right? What would happen to you if you didn't use Live Nation for your promotion? Would you be deprived of your next opportunity? Would
Okay.
you be able to put your next show in one of their amphitheaters? Would you be able to do business with one of their affiliates? Those are the kinds of questions that they ask, right? Would you fear that you would go out of business, right? Without the ability to do business with Live Nation. That's one sort of paradigm. There are other cases where, there's sort of the straw man of, someone who really needs low prices, right? You need the maverick, without which you would not be able to buy a product or service.
What does that mean?
Meaning, if there's like a company that offers particularly low cost, widgets or something that, if they get gobbled up in the market, that there is a particularly low income, family that wouldn't be able to participate in the marketplace without them, right? Like that is part of the harm story that you're telling there. I'll give you another example. We filed a lawsuit to block the merger of Penguin Random House, and Simon and Schuster.
Hmm.
And instead of making that case about the number of books that would be available after the merger, we were focused on author advances, right? Because we had an idea that if they merged, that it would actually reduce author advances that would be available, and that if that number went down, that there would be fewer people who would be writing
That would
books.
be the evidence of the harm is less book stuff happening.
Exactly. And so, we had witnesses take the stand. The first witness actually was Stephen King.
Now that's a story.
It was amazing. It was amazing. And, he took the stand and he talked about how when he was younger, he could make a go of life in the industry, and he could afford to, take time to go off and write a book, and he could live off of his advances. But he was concerned that younger authors wouldn't have those opportunities. And, one by one, we put on agents, like literary agents and authors who talked about how without those advances, certain stories wouldn't get told. And again, in a country as amazing as this one, where the marketplace of ideas has to remain open, right? Because the vast majority of countries on earth, right, are not open societies. It is a profound loss for the number of perspectives and viewpoints to become limited, right? Because we've allowed consolidation, right? That would tamp down on, the ability of authors to just make a
Okay,
living,
but let's go
right?
back to another opening now because you're talking about this case building story, and I do want to go back to Google for a second because it is not
Okay.
obvious to me. And again, this is without any opinion about the merits of the Google lawsuit. I just don't know enough. By the way, I do know enough to know that I want the little guy to be able to succeed, and antitrust enforcement in general makes sense. Blah blah blah. But it's not obvious why starting with an economist is how you begin a morality play. So help
Yeah.
us understand in the case building what goes into those choices.
Yeah. So, table setting. The Google search case, like the theory of it, was that Google has 90+% market share, in general search engines, and also has a monopoly in related search advertising markets, and that its market share is actually much higher, in mobile search, and that it maintains that monopoly through certain presets and defaults. So when you take a phone out of a box, Google pays a lot of money to be the sort of preset on your Android or iOS device. And it would be malpractice for Google not to make the obvious argument that you can already anticipate, which is, well, that's silly. You can just switch, right? And so a lot of the case was about, whether there was something to this idea of defaults. And the first witness in the case was a behavioral economist, Dr. Antonio Rangel. He was amazing. This is actually the first time the DOJ put on a behavioral economist in a case. And he talked about how the human behavioral like dynamics of just having a preset and how like psychologically it's kind of unlikely that you're really going to change a preset. And so he explained this to Judge Mehta, and he went on after a Google witness named Dr. Halvarian, who is a very accomplished, very brilliant man who unfortunately had some very damning documents where he had laid out this theory called the power of default, where he had thought on behalf of the company that, defaults were extraordinarily powerful, would give the company an edge, would help lock in
Mm,
users. And so, like going back to something I said earlier, being a good lawyer, one means listening more than talking. And two, being able to put yourself in the shoes of everyone you interact with along the way. You need to think of the world as Google would, right? Like you would be nuts. You'd be nuts not to try to do what Google has done and is doing. And so, of course, documents like Halvarian's exist. And of course, he should be the first witness because he is the unlock, right? Who tells the world how Google thinks of these presets and the value. And then you put on the behavioral economist who explains the human psychology of it all, right?
mm.
Like, and explains
So it's sort of
Google's not
sender and
crazy.
recipient, doer and done is that what that
Exactly.
story is. It's sort of showing the whole act, if it will.
Exactly.
And for some reason, I thought Susan Athey was the first economist you called. She was not.
She was our chief economist
She was
at
your chief
DOJ.
economist working on your behalf. And so I guess that's part of it too, is you don't really think of lawyers as having economists working for them. And as a failed economist myself, I have great respect for them because I couldn't do it.
No.
And so it sounds like what you were really trying to do was tell the business logic story and the
Yeah.
business logic story from the Google perspective. And by the way, as a Berkeley teacher, I started teaching in the school that Hal Varian helped start at the information school. So I know what a giant
Mm,
he is also, in
totally.
the textbook on information theory, or one of them anyway in the internet age. Yeah. And so was that your like, hey, and I also had a major in bioethics coming out, and therefore I can bring different disciplines together. I mean, there's something that feels expansive about this view of what a lawyer is, that it is a coordinator of many disciplines of knowledge. And I guess I'm just looking for, is that right?
This is the team aspect of it. And, you mentioned Dr. Susan Athey. I mean,
Yeah.
this is why I'm so grateful to have worked with the team that we had. I love Susan Athey. She is a total giant. She's brilliant. I always feel like I could be better talking to her because she could just like crush everyone's spirit because she's so brilliant, but she's also very humble and asks questions more than she talks. And that was the spirit that she brought to DOJ. And so when we put together witness orders and really thought about how we were going to
Wait,
line
sorry.
up
What's a witness
cases,
order? Is that the sequence in which people
the
go, or is that the?
sequence of witnesses, that was part of the tradecraft too. I mean, for certain cases, we would get in a room and, really hash out like what a witness was supposed to do and what they could
Mm,
say and how to order it. And no, we should put this person after that person. And wait, does the story cohere? And how does this work? And, when you have people with different specialties, like, okay, I have bioethics experience and I used to do financial services cases and antitrust. And Jonathan is really brilliant at section two and has a media brain. And, Susan is a computer scientist and also a giant in economics, but she also is published in machine learning. And, Heddle was a debate champion and has tried cryptocurrency cases and dazzled juries. There were just so many different areas of expertise and competencies that you could bring to bear on so many problems. And again, we had to police a $29 trillion economy. And I will say, it goes back to this point about we understood that litigation is a morality play, but I didn't hate any of our defendants at all. I actually had great respect for them.
Mm.
I had great respect for all of the lawyers that came before us too. I knew that they were always going to be hyper prepared. I knew that they were researching everything about us, everything about, what we had done before. And so I never took the trade craft lightly. And I knew we were going up against the best, deepest pockets. And, these were going to be generational cases. And so we pulled out all the stops. We did everything we could to make a go of these cases. So
And so, you're now embarking on these cases or embarking on the part that's seen by the public. It's very rare to have a work project that when you start it will take years and you don't know how many years. It could go for a very long time. People are ambitious, they take new jobs, they have family circumstances change. How do you build a team, given that this is a team sport, when you're like, well, it might be 2 years, it might be seven, I don't know. Like, or is that not the right way to think about it?
the government solves for that.
How so?
And I'll tell you why. You can't pay people enough in the government. And so it's a self selecting group of mission oriented people. And so people will come in to do great work while they can. And sometimes that means getting part of an investigation done. That might mean getting the recommendation memo done. That might mean doing the trial and leaving the
Mm,
appeal for somebody else. That might mean getting the appeal done, just part of a case and handing it off to somebody else because the institutional culture, at least previously, was very, very strong. And we built that up too, right? One of the things that I made my job was essentially shutting down the division, once a year for probably 3 full days and insisting that people come in, according to certain bands of practice and having intensive trainings, like very advanced trainings, including a sort of like ethics and like values primer, right?
hmm.
Like, what are our core values? Like, what brings us here? Including like principles like disagree and commit.
Disagree and commit. That's an Amazon principle.
I love that.
Just noting,
Yeah,
one of
yeah.
the areas that you were known for having opposition, there's something about the parallel of the tools in that. And so, wait, so how does that create the environment of longevity for the team working on something?
There are lots of ways that people can impart their viewpoints on the way up to a recommendation. And in fact, there are places in like written memos where we expressly ask for contra views, right? Like if you don't think it's a good idea, right, to pursue a theory or to bring a case, we want to know about it. Right. And there are
Hmm.
check-ins or meetings, right, where the decision maker will pop in like in the middle of an investigation. And so we hear like where like there are weaknesses. But once you've sort of worked through things, especially if there's like a policy disagreement, right? Should this kind of person be subject to a subpoena, right? Like once that question's answered, can you use this kind of statute for this purpose? You sort of moved on.
Hmm.
Holding on to disagreement and I don't know, sort of getting sidetracked or like bogged down.
Got it. You're discovering the early stuff, and that gives you some longevity. I think the other thing that's interesting here,
Yeah.
when one imagines the image of a trial attorney, what are the things you see on TV? You see a little bit of the research and are they trying to figure something out? You see the depositions that feel almost like a mini courtroom. I realize they're not, but they can feel that way. And, I'm aware that there's a lot of writing involved. So this is the first time you sort of alluded to the memos that get written. What role does
Yeah.
writing play in the trade craft of being a litigator?
It's hugely important. Your thinking is only clear when you can deduce it to writing
Mm,
clearly. I strongly suspect we are the only profession that learns by reading. I'm open to being
Hmm.
challenged about that.
Well, I would say academics probably in some
Probably
domains learn
true.
by reading. Yeah.
Yeah, I mean, we learn hugely by reading, and it is very important that we be able to logically lay out like our reasoning because that is how courts expect to get our argument principally. There are pretrial briefs, right?
Hmm.
A court will sit with a complaint and only the complaint in a government case for years, years often until there's a pretrial brief.
Wait, so I don't fully understand this part because I kind of imagined, I guess, I know when like somebody gets sued, there's that long document where it gets filed that makes a bunch of arguments. Is that the pretrial brief or is that something else?
That's probably the complaint, right? And the
Yeah.
complaint, it's hugely important. I, again, just to like confess my full nerdiness here, I gave a speech at an event called the Antitrust Writing Awards, where I gave like a huge ode to the importance of writing in antitrust. Like we have a written tradition, and I spelled out how important complaints are because they are part of how we tell the public how we are using the power entrusted to the government, right? And whether we are making careful use of that power. And so the long document contains the allegations against a defendant, right? If you were that defendant, you have to read that thing to see very clearly what the allegations against you are, right? What law is the government saying that you violated? How did you violate that thing? What are you supposed to answer for? The pretrial brief comes much later after there's been subpoenas, after there's been depositions, after there's been sort of a narrowing of the surface area of disagreement. There's a whole pre complaint discovery
Mm-hmm.
period, like
And that includes
investigation
the
period.
depositions and requests for documents and stuff like that.
Yeah.
Yeah.
But then even after a complaint is filed, there's still more discovery, right? And again, this is limited to like government litigation. There's still more discovery and still yet more narrowing of the issues. And so for a court, it's very important that the complaint be tightly worded and carefully worded, right? The government can't just go saying anything. And again, we used to pour over every single word. When I was a trial attorney, I would actually have comment bubbles over every single sentence and ask for the document from which like that sentence, was derived. And so I'd want the source, right? Doha removed this mug from the room on March 20th, right? I would want the exact source and file hyperlinked so I could check it. And we would spend the entire, 48 hours before site checking to make sure that there was not a single misstated sentence in the entire complaint, right? That's how important writing and sourcing information is. And then again, in the pretrial brief, by that point, those are your arguments. You are marshaling the law and the facts, right, to persuade a court
So help me
that you're
understand. I may have
correct.
a misunderstanding here. I guess when I imagine what happens in the courtroom is that's when you find out what the person's arguing. There are surprises in the courtroom. And that's not the case. Does that mean the courtroom
No,
itself is a pre-scripted kabuki theater?
it's actually a wonder of our system. And it's
Okay.
actually a wonderful thing about our system. There shouldn't be surprises. There are so many rules and laws that make it such that, there really shouldn't be surprises once you get to the courtroom. And so, the point of court is so there's a neutral arbiter and like a hearing of a dispute, right? But there shouldn't be surprises by the time you get there. And again, there are opportunities to settle, even if it's not a whole, like a full settlement. Like, let's say there are five grievances, right? Maybe you can resolve two of them. Maybe you can resolve one of them.
So it's trying to make sure that what remains in the courtroom actually does in fact need to be disputed. It's a way of making the
Exactly.
resource more efficient. It's previewing for the purpose. Okay. But so then by the time you get to the courtroom, can you make new arguments you haven't made in the pretrial brief?
No,
Weird.
no.
So how is it not kabuki theater then? if you know all the arguments. It's performance art, basically.
Well, the issues are hard.
Yeah.
The issues
Okay.
are hard. They're hard. Again, you're not getting to court unless the facts are disputed. Maybe reasonable people disagree about which way it goes. Maybe the judge has their own questions. And again, that's what's so interesting. If you have a case where it's not a jury deciding, but it's a judge deciding, like you mentioned with the behavioral economist in the Google case, Judge Mehta was asking questions himself. I mean, he was looking into the witness box and asking important questions that later were reflected in the liability decision, finding that Google had, in fact, violated the antitrust laws. Right. So, this is important stuff.
Yeah, that makes sense. Is there more on writing that if you were like telling an aspiring lawyer something about the role of writing in their career, you would tell them? And of course, this is not advice because you're just sharing your perspective, but I'm asking you what you would tell a lawyer like that, you know?
The best advice I got about writing is that you can read more good writing than you can actually write, and to read as much good writing as you possibly can. I think the standards for writing are declining fast. And so, gosh, read as much fiction as you can. I don't do a good job of this, but you don't have to make my mistakes. Read lots of fiction, read classics, read Hawthorne. My mom was really keen about this. This is a total immigrant parent thing. She was a stickler about reading classics.
Are there books, stories, fiction stories that are the guides on not just on writing and reading, but on like that you carry with you? Look, you are case building a morality play. Much more relevant for the fiction stories that you carry in your heart to be present and relevant then versus for the textbooks that are in your heart. I mean, if we even have textbooks in our hearts.
Read The Great Gatsby, A Streetcar Named Desire, right? Like
Okay.
total classics, right?
I love, but how come?
Yeah, I mean, these are the things I used to assign to my
Okay.
US history students. They are period pieces that help you understand the mood and sentiment of the moment.
I guess I also hear in that empathy for different perspectives. I mean, if you're
Yeah.
seeing the other side of the case as a fundamentally, good actor trying to do good, maybe isn't quite the right word, as a respected actor trying to do things that make sense from their point of view, does fiction help with that?
I think that's right. I think that look, when you're talking about the morality play that is litigation, I think being able to stand up the straw man, actually, it's not even the straw man, it's like the steel man straw man of every argument. You need like an expansive, like sort of set of characters in your like mental repository that you can sort of bring to bear on like what kinds of stories that you want to tell. Right. And so it's not that like, I don't know, reading like historical pieces isn't going to help you with that. Like I was a history teacher. My husband is a historian. Like we
Oh,
love
cool.
history in our house. It's wonderful. But I don't know. There's something to be said about fiction pieces too.
Okay.
I think it's useful.
You know what? One of the things on like the use of fiction in professional life, first of all, I've noticed it in tech, this is probably obvious, but the fictional stories that are often inspirational are science fiction.
Mm,
And that's really good for imagining a future in terms of how it is built, but it is only inconsistently good. It can be really good and beautiful in imagining a future in terms of how it feels. So
mm.
what's interesting is we've now been talking for a couple of hours and we barely even touched on what happens in the courtroom. Yet when one imagines a litigator, one imagines that as the main thing the litigator is doing all day long. So first of all, I just want to note what a small piece of the overall process time ends up getting taken by being in a courtroom, or it seems, you can correct me. And just tell me like what makes a lawyer great in court?
There are so many types of legendary trial lawyers. And people imagine that, every trial lawyer is maybe a Johnny Cochran or maybe it's an Atticus Finch.
I'm going to say actually the olds, maybe the only ones like me who remember Johnny Cochran, who was, legendary defense attorney who defended OJ,
Yeah.
very charismatic talking version of the lawyer. Like you get him in the courtroom, you don't even have to prepare. Just hand him a bunch of pieces of paper and he'll improvise the most incredible argument on.
Yeah.
That's the myth that I imagine.
Yeah, totally. So Atticus Finch, like literary character, do-gooder, wears the white hat, lawyer with a good heart, stands up to make the like great moral argument, right? Like that's typically like what you think of as like the amazing courtroom lawyer.
Yeah, I think of in Inherit the Wind, was it Clarence Darrow who was the
Yeah,
inspiration.
totally. Totally. So it takes all types. And I think that's true in the courtroom as well. A few things that I think make courtroom litigators and trial lawyers effective. They listen more than they talk.
I'd be terrible.
No, that's not true, Roy.
But sorry, keep going. So
They
they're
are.
listening more than they're talking.
They listen more than they talk. And they are exceptional on their feet. They're exceptional on their feet. People who cling to an outline, who need a lot of paper, who are very like stilted and need to follow a rubric, that's probably not your environment. They are people who are able to adjust and consume huge quantities
Mm,
of information and go with where the witness is going to go. Because if you ask a question and a witness says something that you do not expect or that gives you an opening, you need to be a master of the rules of engagement and be able
hmm.
to ask a follow up that may be an important unlock.
Well, so this is where I'm just trying to follow because all the arguments are already previewed. So what's the line between a new argument and not allowed and a improvisation or a response to the moment in dialogue with a witness that is allowed? So like I guess, this is where I'm trying to figure out, you're not quite scripted in everything you've said, yet the arguments are cast in stone. So just help us understand a little bit about where the line is.
Well, it can be a matter of how they described, their reaction to a meeting. When the CEO said, don't poach from this competitor, what did you think?
Yeah.
Right?
Yeah.
And in the deposition that you took, that witness told you, well, I don't poach from them anyway because I don't think their workers are very good, right? They don't train their people properly. But in the chair, they say, well, that was confusing. Well,
Mm,
that's different from what they said in the
mm,
deposition. But you have
mm.
to know that, right? And you have to say,
Got
well,
it.
wait a minute. What do you mean that's confusing? What do
I
you
get it.
mean? You
Okay.
know?
Yeah, it's funny. When I was a high school debater, I guess that's my closest thing to being a lawyer. And obviously, many of the people who I debated with, one's a judge now. Hi, Sanket. Maybe we'll get Sanket Bulsara in here on how to be a judge. He loves doing
Awesome.
citizenship swearing ins, which is, I think, the coolest thing that he gets to do that.
I've done 2. Amazing.
I bet,
Absolutely
especially
beautiful.
given you also personally experienced that.
Yeah,
But there's a way in which that the practice is just understanding. So like what we used to do in cross examination was just, what do you mean by that? Wait, how does that work? And then you'd eventually get down to the point where a surprise, and I guess this is a generalizable lesson, it's true for startups too, and actually Elon is kind of the notional peak practitioner of this technique, which is getting back to the basics, which is keep asking questions until you realize, even for
totally.
many experts, there's some bedrock assumption on which everything rests that they just have never really examined or can explain. And so I guess there's something really cool about, I don't know, it sounds like less the act of argument than the act of elucidation.
Totally, totally. And Susan Athey is the master of this. And again, Susan Athey is the most brilliant person I have ever met in life. She will just ask the question without fear of, sounding dumb because everyone knows Susan is the most brilliant person ever, and so she'll say, "I don't understand that. What do you mean?" And so, it's given me more confidence to say, I'm so sorry, I just don't
By the
understand,"
way, I
or
don't know is such a powerful expert thing. And I've seen some, great business leaders who are, really good at the, wait, can you explain that to me again? And it is a very powerful technique and it takes real confidence. The junior person on the team may think, and they might sometimes be right, I should know that. And then sometimes I'd like to say no dumb questions, but there are obviously dumb questions. The junior person on the team who's like, I don't understand. It's like, buddy, your one job was to understand that thing. And so,
Mhm.
your point that they be able to confident, and I would like more junior people to, of course, be confident expressing they don't know and take the risk of you should know. Cause like, okay, fine. So they said one thing they were supposed to know. Who cares? Like, do they perform well? Move on. But that process of cross examination as the act of elucidation, as opposed to leading questions, seems really powerful. Who is the audience for what's happening in the courtroom? Because like sometimes there's a jury, I guess sometimes it's the judge, but if the judge already knows the arguments that you're making, does the jury already know the arguments? If there's a jury, like help me understand, to whom are you communicating this somewhat pre-baked, half improvised, half pre-baked play?
Yeah. So remember that if the arguments are pre-baked, what we're talking about is a vessel, right? Imagine a huge bowl, right? Like you have to like fill the structure, right, with like content, right? Because that's what arguments are, right? They're just like elemental structures, and you still have to pour fact into them. And so the point of the trial is to fill in those facts, right? Like you might preview them in a pretrial brief, right? These witnesses are going to testify to the following things, right? How the company prices these products, how they think about the preset or the default. But then you go about doing it. You are right that the judge and jury act variously as like triers and finders of fact. Sometimes, and this is very important, the audience is a decision maker about whether to settle. It's a decision maker about, an important communication.
When you say whether to settle, that's the other
Yeah.
side on some level too. They're the audience as well.
Yes.
Fascinating.
Absolutely.
You're making an argument notionally to the decider on behalf of the system of justice, but actually the subtext is you're also communicating to the other side, like, hey, you're losing, time to come back to the bargaining table.
Totally. There are often good faith discussions about whether to resolve an issue happening even during a trial. And these are hard judgment calls, especially when you are the government, about whether to continue to entertain these discussions, right? If you're in a criminal case, is that a good use of the government's time when the facts are baked, the crime has happened, the plea offer has been, floated and been rejected? Is that great? In a merger context, right? When there's an asset package that's been floated, it's continuing to be improved. If you're the government, you want to continue to listen because they could go off and ink a deal without you, right? And so
Mm,
you want to be talking. You lose
mm.
nothing by continuing to engage. And so when I was the decision maker on mergers, I always was like, "This is my cell phone number, like, y call me," right? If there's something to talk about, the deputies know how to get a hold of me if I'm busy, like, "What's going on?"
I love that. And so wait, so there's an aspect of the tradecraft of doing a case that I don't think we alluded to but didn't talk to, which is there's this parallel track of going to court and settling. And so how do you think about whether to settle versus go to court, but also during the court process as it's unfolding, how that interleaves with trying to figure out whether to settle? That's just like a fascinating, it's almost like a dual track happening at the same time.
I think that it is always worth continuing to talk unless you think a company is intentionally trying to waste your time or there's something bad faith happening.
Sorry, continuing to talk means being open to a settlement on some
Yeah,
terms.
totally. Unless you think there's something bad faith happening. I have encountered those situations. It's been rare. But again, if you think that, companies are trying to accommodate a concern, that you've been clear about your concern.
Wait, but so let me make sure I follow that. I guess what that implies is that at any time there is some price on which, assuming it's all good faith actors, you would rather settle than continue the courtroom case.
No.
Okay. So when
So,
isn't there a price at which you would settle, and
yeah.
when would you settle?
Again, this is the minutia of
Yeah,
antitrust law, but this is important. This is
yeah.
important. Again, we live in the United States, and the law, which we all have a lot of regard for, is very important here. Congress actually set down a marker that tells the public where it thought the price should be. And there's this concept of estoppel.
ESTOPPEL. One of these words that I've seen go by, and I'm like, that can't be a real word. You can barely even
Yeah.
say it. What is estoppel?
Yes. So there is this provision in the antitrust laws that basically suggests that after the first witness is sworn in a government antitrust case, that the findings against a company basically operate against it for the rest of time. And so, if you are going to settle in a government case, you really should do that before the trial actually begins, right? In your like monopolization cases and so forth. It's kind of a waste of resources, and it can undermine the company. Like if a company really thinks that it's done nothing wrong, or it's facing litigation in a number of other fora, right? It's facing a class action in some district, it's facing government litigation, it's facing state lawsuits, right, with state attorneys general. Maybe it is facing foreign competition authorities, right? Because there's a whole international dynamic. Like, facing those odds, you really want to be careful about liability and exposure. And so, if you're going to resolve something, you want to resolve your liability in a way that exposes you the least. There's a game here if you are a company facing these circumstances. Also, as a public enforcer, you never bring a case unless you really believe that a wrong has been perpetuated against the public. And it is important that there is a public telling of that wrong.
That's the trial.
That is the trial. That is the trial. The point is not to embarrass, right? There's nuance here, right? It's not about airing out grievances, it's not about embarrassing companies, it's not about embarrassing executives. But if you are not able to resolve during the many years of investigation and post complaint discovery, it's probably because the case is complicated and both sides believe there's an opportunity to prevail at trial. And there is an important public right to be vindicated by going to trial. And that is important too. And I think enforcers should not lose sight of that.
I mean, settling during the trial might bring some of this stuff to light too, wouldn't it?
Certainly. But again, if you're talking about a big monopolization case,
Yeah.
I think the odds of a settlement mid-trial are hard. I think the mergers are
Because at that point, enough is
more
already
likely.
known that you're really playing the uncertainty of what the judge decides, as opposed to the uncertainty of some surprise in the courtroom that reveals some new fact that all of a sudden the defense feels like they're on their heels or something like that.
Yeah, I don't, and again, it's not really surprise. I just think it's the circumstances of the cases themselves, right?
Yeah.
Mergers tend to be forward looking. There might be like, asset packages or just like circumstances that help you resolve a concern, or the conduct of trial maybe helps merging parties see this is not going well. It might be time to abandon the merger, or it might be time to find another merger
Got it.
partner, right? Monopolization trials are just a different beast altogether.
Yeah, I mean, I love this awareness that actually the dynamics, the chess game, the board game part of this really varies depending on what kind of law we're talking about what kind
Right.
of issues, and that it's not about the dramatic surprise. It's about shifting circumstances, in the outside
Totally.
world. My last question about how you make the case before we zoom out to sort of how these organizations work and the careers and systems. You won the Association of Attorney Generals Award of Distinction a couple of times, if I'm not mistaken. I know that it's going to be hard for you to answer this. So I'm going to ask it in a way to make it easier. If somebody else in the legal profession who knew your work were describing why you or why someone would win such an award twice, what would they say that makes that attorney distinctive?
Oof. Okay.
See, I made it so you can't wriggle out of this one.
I did get the AAG's Award of Distinction a couple of times. I think the first time I had a really wonderful year at the division. I was a trial attorney and worked on a few matters, including a couple of mergers, one of which ultimately was abandoned, one of which yielded evidence of a couple of conspiracies. And that's the stuff that I loved the most when I was a trial attorney at the antitrust division. Like mergers are cool, monopolizations cases are cool, but cartels and conspiracies, like coordinated conduct, like that's my favorite. And one of those conspiracies ultimately was what became the last no poach, like worker no poaching conspiracy that was sort of grandfathered in under the old policy of treating those conspiracies sort of presumptively as civil violations of the antitrust laws.
Sorry, when you say policy, it just means an agreed approach by the government. It doesn't mean a change in
Yeah,
law, does it?
it does not mean a change in law.
Yeah.
So basically, there's the Sherman Act, there's Section 1 of the Sherman Act. It is a felony statute. It is a bit unusual because it can be charged as a civil violation or a criminal violation. And there are not that many statutes that operate that way.
I see. So meaning that the
For,
enforcers have a choice.
yes, the vast majority of conspiracies are charged as civil violations of the Sherman Act, but a narrow category are charged as criminal conspiracies.
Hmm.
No poaching conspiracies are essentially just an agreement between employers not to recruit or solicit workers, in various ways, just to soften the competition between them for workers, right? And it can look a variety of ways. That had been treated civilly. The most famous sort of example was in the Silicon Valley context, right? Adobe, Apple, Google, Intel, Intuit, Pixar, Lucasfilm, they had all had these no poaching arrangements.
Meaning they
And
agreed not to hire from each other's staffs. And the idea is that that comes at expense of the software
workers,
engineer or marketer
exactly.
or attorney who works at one of these companies and would benefit from the other companies bidding for their talents.
Correct. And so looking at this and also recognizing the country was recovering from the financial crisis, we had folks in the White House at the time sort of thinking about this two-staged recovery from the financial crisis and why some workers really had not recovered from their losses in the financial crisis. And, they really wanted to focus attention on these types of arrangements and whether they were maybe more prevalent across the economy. And so they directed the DOJ and FTC to go looking for more of these or use their authorities more intensively
And that means like
here.
you write the head of HR at many companies and you say, please give me all documents pertaining to a possibly secret agreement you may have.
It means alerting the public that these types of arrangements too may run afoul of the antitrust laws. And I
Got it.
think within DOJ, there was a recognition that for reasons having nothing to do with the law, these arrangements were treated civilly when in fact they were no different from other kinds of agreements that were charged as felonies. And so I think there was a big question internally about if two movie theaters agreed not to solicit each other's customers, you would send the FBI after those movie theaters. But if two employers agreed not to solicit each other's workers, that would be like a slap on the wrist kind of like civil
Right.
arrangement. And so that's what we found in this merger.
And so meaning one of the themes, and I guess we're now talking policy, but let's hit it for a second. We can bracket it for talking about the system, is that under your approach, I guess is the word I'm going to use because I'm intentionally not using a term of art like policy, you were treating harms to people in their jobs on an equivalently damaging level to harms to people in their capacity as buyers of services like consumers. And I guess this seems to me like one of the major shifts in antitrust approach over the past few years has been
Yeah.
prioritizing the needs of small business and of employees in a similar way to how we would have prioritized in the past the effect of monopoly on making you pay more for something at the store. Is that
Correct.
okay? And so let's zoom out for 1 second then and start talking about how you sell the work, which is to say, you're talking about a rationale that is making something public. And it seems like in building these cases, you are convincing a boss who is a political appointee, let's say, or in private practice, it might be a client to go about something. To what extent do those contexts differ in making the case about taking on a case? And
Yeah.
just tell us a little bit about the selling, the persuading around the need to do the work in these settings.
Yeah. This is at least one reason why I'm very grateful to have worked for both Republicans and Democrats.
Yeah. And by the way, same here.
Yeah. Yeah. I also noticed that about your background and think that is a very cool thing that we share. It was actually Macon Delrahim who gave me the opportunity to come to the front office and really try to make heads or tails of this
Sorry, what does that mean
policy.
to come to the front office?
Yeah, sorry, living in DC is
Yeah, yeah, yeah.
there's some brain rot here. So the front office is the head of the antitrust division and their deputies. So it's the sort of leadership kind of like nucleus of the antitrust division that oversees the 800 person staff or so of the division. And so I had a chance to be his counsel and try to rough out a policy for how the division was going to treat, these worker no poaching arrangements and wage fixing conspiracies. But at the same time, I learned a lot about non-competes and monopsony, right? Which is monopoly exercised on the buy side of a market and information
Meaning
sharing
a
and all of
monopolist
these
sells something as the only one, and a monopsonist is the only buyer of something.
buyer.
Yeah,
Exactly.
got it.
Exactly. And convincing more of a sort of libertarian, government hands-off approach to focus on workers requires a sharpening of your arguments and selling it as something that is actually good for businesses too. And I'm not here to convince anyone that policy is only good when it's good for business, right? I think we should
Sure.
have a focus on workers because that is good for its own sake. But it does mean getting good and practiced at helping different stakeholders and people with different worldviews understand why certain policies are good for them. And I really appreciated that opportunity tremendously.
Can you show not tell us a little bit about, because between the private sector, the public sector, Republicans, Democrats, you've probably had to make the case in many ways about making the case.
Yeah.
Like I get the narrow, you will make more money as a business if we take on this case. Like that feels like a simplistic take. But what are some of the different archetypes of the ways you convince somebody to go along?
Well, I'll give you two examples.
Please.
One way you help people understand this is, the National Economic Council at the time was very focused on new business formation. It had declined substantially at that point, and it was, stagnating a bit.
Pre-COVID kind of thing.
Exactly.
Yeah.
It is difficult for new businesses to form and really get off the ground if workers are locked up or like captured by businesses and incapable of being like poached or like recruited over. And so this is a business problem, right? If I start a great new company and I cannot hire people effectively, even if I'm offering a better work experience, I'm offering great equity or options, and I can't get them to come over because I don't know, there's like, some kind of no poaching arrangement or there's non-competes or something. That is a business dynamism problem, right?
I know what dynamism means from my failed economics experience. What do you mean when you say dynamism?
It's new business formation, right? It's new ideas like seeding and
People
like
moving
growing
around,
to the
trying new
market, people moving
things.
around.
Yeah,
Yeah. Right. So these are things that make America distinctive and a cradle of innovation, right? And makes us more competitive on the global stage. Also, and again, not to get steeped into the politics or make any claims about what anyone's politics are, but for better or for worse, Donald Trump came to office campaigning in 2016, speaking to a certain kind of aggrieved American, right? There were people scattered about the country who were upset about a system being rigged, right? And their economic opportunities falling by the wayside. And speaking to those Americans was very important, right? And a policy coming from a Republican administration that even named workers was unusual. Right? I mean, that's like not consistent with
totally.
Republican orthodoxy at all. And so again, I'm not here to make claims that it was, you know, a new deal of any kind or anything that was like groundbreaking, but it was different, right? In texture and in rhetoric.
So I think what I hear you saying is that surprises in the circumstances, including the political circumstances, can create opportunities to link the things you want to work on to those new themes. And yeah, I mean, I think one of the tragic things that often happens in business, and it happens obviously more in politics, is you have different teams. In politics, there's the Republican team and the Democrat team. In business, you might have your company and the other company. And sometimes it's really hard to take the best of the other team's ideas because if you
Yeah.
even adopt one of them, you can be accused by others of disloyalty to your team. And I think that gets in
Yeah.
the way of good decision making. And so the absence of orthodoxy can be surprising. And then when you do something surprising, I mean, for example, the nature of the antitrust policy under the Biden administration, I think was for many in the tech industry surprising, not always a good surprise. You all of a sudden get accused of being an ideologue on having all kinds of other views that you may or may not have. So I feel you on that,
Right.
having worked for Rupert Murdoch and Michael Bloomberg and, myself as an entrepreneur, the differences can sometimes surprise people.
Yeah.
But I want to put it back into the context of running a career. And so, you're kind of persuading others about the work in different ways. But then you already alluded to lots of other persuasion you're doing, like on your team, identifying issues they may have and rooting them out early. Like, would just love to hear what are the other
Uh-huh.
places in which you find yourself doing, maybe collaboration is a better word than persuasion, sort of things that may feel more like management, if you will, with witnesses, with teammates. Like, just give us a sense of what role, like if I had to take the typical office worker who is in a managerial chain and they're communicating with partners and employees and their boss, and the typical litigator who is in a different kind of setup, what does all that collaboration persuasion look like in a litigation setup?
Yeah. For the typical litigator, you know, especially if you're in a case with a lot of plaintiffs or a lot of defendants, you are coordinating across a set of lawyers. And so you might be collaborating and frankly compromising on things as mundane as who takes what deposition when and who gets to ask which questions when. You might be negotiating things like, how to draft parts of a complaint in my role at the Justice Department, there are so many layers of management within the antitrust division, but also the antitrust division was just a tiny part of a 100,000 person organization called the Justice Department. And there was an attorney general that sat above the antitrust division. And then there was the labyrinth that was the federal government. But then we also had counterparts in the state attorneys general and foreign competition authorities. And there was
Yeah.
constant push pull, right, on everything.
So that actually sounds, I'm going to exaggerate the point only slightly. That sounds identical in some ways to a corporate context where you have business partners in other places. You may have parallel divisions of the same business. I mean, obviously, the government is a much bigger company than the typical
Mhm.
company, but what does it take to thrive in doing that? Or would you just say, hey, read regular management books and listen to managerial thinkers and figure out what Adam Grant and Brene Brown and Kim Scott and whoever says about how to do well at work? Or is it different in some way, given that it is legal work?
Again, going back to 2 things we talked about earlier,
Yeah, please.
this is the superpower of the immigrant child. When you have been pulled out of one context and dropped into
You're a
another.
context walker.
Totally, and
Yeah,
so,
powerful.
yeah, you just get used to, having to listen and relate to
Yeah.
people who are very different from you all the time. And so it just sort of comes to you. I don't know if naturally is the right word. Maybe it's just, I don't know, you just pick it up at some point.
Yeah, I mean, I don't know. Naturally is one of these things that can imply there's no agency in it. I
Yeah,
see, and obviously not all children of immigrants or immigrants themselves are capable of it. But I think what I hear you saying is that environment creates an opportunity to learn all those ways of doing things. And if you pick it up, then it can feel like second nature to you.
totally,
Yeah.
totally. And you just get used to, I don't know, just having to understand different viewpoints. And you also get very good at translating other people's views
Mm,
to another decision maker. And so, being able to smooth frictions, to advance the ball, to help get decisions made a little bit faster, that has always helped me in my career. You see it representing companies, right? Sometimes there's an associate GC that you're working with day to day, but an actual decision rests with someone in the C suite.
hmm.
Really big decisions have to go up to a board. It's just the nature of life. And
Yeah.
even as a business owner, so my dad was a business owner his entire life.
What
He's
kind of
sort of a
business?
funny character. He owned a construction company. He was also an architect. But again, life as an immigrant, like there's
Sure.
the whole credentialing thing, didn't bother doing that. And so did the sort of construction part of it.
Yeah.
But he's a funny character in that he's never had a boss. But of course, even a business owner always has a boss. Everyone has a boss. Like it's just what it is.
Well, the customer can be your boss. In our case, we choose to see founders as our boss, but it's also a choice of where you vest that power in someone else.
Yeah. And so you just have to get good at putting yourself in the shoes of every counterparty and trading partner that you're dealing with. Right. And so whether you're a lawyer or a business owner, I
Totally.
think that's life.
Yeah, I think that there's a case to be made that the most essential skill in professional collaboration, with which I include management and partners, is empathy. And empathy makes it sound actually not quite right. It's like you can feel what they're feeling. It's inhabiting of multiple perspectives simultaneously. And that includes
Totally.
feeling, but it also includes the understanding of self-interest, the organizational dynamic, the thought processes, the ways of communicating. And, I don't think that's sufficient in and of itself. I know lots of empathetic people who can't execute their way out of a paper bag, but we often see sociopaths succeeding, and they succeed in a limited way, which is to say, they can set the goal, they can make the decision, but they sometimes have to kind of cosplay empathy with the other person's perspective or inhabiting the other person's perspective. And so, yeah, I think that's really a powerful take. And, with your permission, I want to shift. We've got a couple more topics.
Yeah.
Is to shift to running your career. because
Yeah.
empathy and perspectives are part of that. And we'll talk a little bit more and zoom out about, the system, if you will. But let's just talk about how you progress in your career. So, well, first, I'll just ask, how do you progress in your career as a lawyer? Like, how did you think about phases or things you're working on then and now? I mean, just any mental approaches to how you think about career progress.
Yeah. So I think about career progress in the following way. I do think you have to pick, an early job according to your interests. I spent my first law school summer at the United States Attorney's Office. One of these federal districts, there's 93 of them. If you took the entire map of the United States, they're carved up into 93 districts. They're part of the United States Department of Justice. And geographically, they enforce the federal laws in that district. And so I was in my hometown in Charlotte, North Carolina, and I really liked the feel of federal prosecution. I liked the mission oriented sort of approach to that. And so I knew nothing about antitrust law, where to find the antitrust laws, but I knew that I liked what those people did. So I worked on gang prosecutions, I worked on an MS-13 prosecution, I worked on white collar fraud, I worked on a slavery case. That was crazy. I really liked that work.
Sorry, that went by quick. What is a slavery case?
Oh, yeah. I was not aware until I worked on that case. There are untold examples of human trafficking and people being enslaved, like passports being taken, locked away, and people essentially being made to work in this country against their will.
Yeah, I mean, I definitely know about, trafficking and sex trafficking and people being held captive. I guess now that you mention it, I remember that your colleague in the federal government, who was the acting Secretary of Labor, Julie Sue, who before that was in the comparable role for the state of California, where she did a future work commission. I remember she got famous for a case involving wage slavery, basically, of people who were forced to work, not just for low wages, but without their consent. I think in a garment, setting, and they were immigrants
Yep,
who otherwise, the ability to take a passport from someone is such incredible leverage, especially
totally.
when the countries they are between may be a country they want to live in, like the United States, and a country they don't want to live in. I mean, I'm not saying every case is like that.
Yeah, yeah,
But you see these incredibly powerful circumstances.
totally. Totally. And again, I loved the feel of it. I loved going to court and just watching proceedings. I loved going into chambers with AUSAs and applying for search warrants. I loved working with agents. I went to the shooting range with ATF and the FBI.
In case you got shot at, why were you? I mean, I'm not questioning it. I'm just curious what the reason was, or it was just fucking cool.
It was really, really cool. And it was, I think, recruiting for the lawyer agent program. I think in another life, I could have been an FBI agent. But in this life, I am my current embodied nerd form. And so I'm a lawyer and not an agent. So
Yeah.
that was great. So that was really the foundation for me.
When you say the foundation, it was the foundation of your intention and desire. You were like, this is the thing that I am interested in.
Yeah,
Got it.
totally, totally. I did lots of writing. I saw the arguments, the experiences were cool. Like I was like, this is a law setting I could
Yeah.
see myself in, and it was great. It was great. Again, I went off to a law firm. People have their views. I am glad I went to a law firm.
When you say people have their views, you may be assuming there's some judgment out there.
There's judgment out there.
What's that judgment that's sitting behind your sentiment there about going to a law firm?
So look, there's just the drudgery of being a first and second year associate in big law.
Well, first of all, what is big law? What is the drudgery?
Yeah, look, going to one of the like 100 or so largest law firms in the country is grueling. I mean, the hours are
Right.
extremely long.
Longer than being in the government.
Oh my gosh. Yeah.
Okay.
It was long, like long, 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 like routinely working into the wee hours of the morning, starting again quite early, at least one day of the weekend, like it wears on you, and often like low level work.
Makes sense.
That was not totally my experience, right? With like the low level work, like there were things that made my experience great, right? And that were transferable. But I also, learned great things about writing. I had stand up experience, right? I got to argue motions. I had this kind of cool financial services practice that got me into the New York State court system, which is a trip. It is the opposite of the elite, is sort of antitrust world with big name, household name companies where there's a lot of the important churn of American business happening, right? And that was great.
Okay, so you're in the firm environment. Were you trying to stay there forever, trying to get something out of it before going back to plan A, which was being, in that setting you'd loved over the summer? How did you think about progressing?
So I got a call to join the firm because they represented AT&T in a merger challenge, and they were like, "We need people to start ASAP." Because it's a all hands on deck moment. And I was shocked that I was in the antitrust group because I had one antitrust assignment in law school and hated it. But I loved working on that matter and then continually worked on antitrust. And remember, this is right after the financial crisis. So I was one, lucky to have any law firm job. And two, the government had sequestration, there was no hiring. And so 3 years in, there was a lift on sequestration, and the DOJ put out an ad for relatively junior lawyers. And I thought, maybe this is my moment.
Hmm,
I loved the US Attorney's Office. Maybe I should try this. And I was very fortunate to have an offer at the Justice Department.
got it.
And, mentors at the firm, supported my decision to go to the DOJ. And, there are a few things that I think guided that decision. One is to go where the opportunities are and to be confident enough that you can do something different and that you're not like leaving a path forever. It's very scary. That is contra the immigrant experience, right? Getting off of a safe path is just like not what we do. But what is the point of investing in this career and education and, all of this judgment if you don't take risk to do interesting
No,
things?
I mean, look, just offer a couple of parallels. I gave a talk years ago to a group of Rhodes Scholars about how do you take career risks when the safe options are so attractive. Oftentimes people take career risks because their safe options are unattractive, but there is a certain, if anybody can do it, it's me. But also there's like a tradecraft to knowing, to being savvy about it and knowing when to take the risks. I actually just got a very gratifying email from one of the people who was there at that talk who I'd not spoken to in years afterward. It was like, your talk caused an 8-figure exit. And I was like, that's cool. But there's also this thing about that transition from the private sector to government, which I was by the way, analogous, an associate at a consulting firm. And, the city that I was born in was attacked. And I went to go work in the city government. And this is post 9/11. And yeah, it was just funny hearing how people there thought about it. And in that case, it was a you can't come back kind of a thing, unlike most law firms. And, on some level,
Wow.
it's like, if not now, when? But also the confidence that there might be something equivalent available. And to be clear, there was not. When I left government, I was unemployed for almost a year. So, like, I took the risk and felt some of the pain around it. But, these are the judgments that we make. And so you took a risk going into government. And in a weird way, your whole occupation involves managing different risks. What's the chance we're going to win? The litigation risk we talked about earlier. And so, does the cobbler's kid have no shoes thinking about risk in their own life? Or are you an expert already at some point at thinking about risks because it's in the air in the occupation? So, to what extent can you take the occupation's tools and apply it to your own professional progress?
Yeah. I I'll tell you why I don't see or I didn't see the government as risk
Okay.
to anything except my bottom line.
Okay. Yeah.
It was a
But it
huge
wasn't
pay
risk to
cut.
your bottom line, actually. It was a price to your bottom line. I think that's different. You weren't taking a chance. You knew it was going to hurt the bottom line.
That's true.
That's just
That's
a
true.
price.
It was just like it was a
Yeah.
huge pay cut.
Oh yeah, I mean, I took a 50% pay cut going into, and my logic at the time was I was paid small enough that half of small enough, I'm still barely making it, so somehow I'll have to figure it out. But my line then at the time, unfortunately, I met my wife in my next job, was could I afford to take somebody on a date once a week? If I could do that, then I was like, I'm getting paid enough, make my rent and afford to take somebody on a date once a week, which I did not have to do. It was an aspirational bucket. Anyway, sorry, Doha.
That's a nice aspiration. Yeah, I here's what I did think about. Would I go to the government and have good opportunities? And could I exercise enough control
Mm.
over my opportunities? Like, could I get good cases? Would I have autonomy to work on interesting things? And that is risky, right?
Within the government, there's risk of that.
Yes. And as everyone knows, hopefully everyone knows, your opportunities are so affected by who you work for and
Totally.
who you work with. And so I was very fortunate because I worked for a woman named Mary Beth Patrizzi, who was my first chief at DOJ. And the section was run by all women. And they looked out for me and gave me case lead opportunities before I thought I was ready to lead cases and lead investigations. And they just didn't let you fail, which is amazing.
I love that detail. Well, or they gave you some opportunities to fail without consequence or try things on or something like that. You know, the desire to have good opportunities in the new job makes a lot of sense. I got similar advice leaving McKinsey. Somebody's like, don't go if you're not going to have a lot of influence. And I was like, well, I don't really know, actually. And in my case, it was easy because it's like, look, this is a historic moment. I'm going to like go work for the New York City government after 9/11. If all I end up doing is being a fly on the wall, it's still worth it for the kid who grew up in New York City. But for some people, that is about the experience of the job. And for some, it's about, I'll use the word investment. They're like, well, I'll go into the government because then on the other side, if I go out and get a job in the private sector again, I'll have an elevated set of skills, relationships, perspectives. And so why were you wanting the right cases, the right projects to work on? What was the driving motivation?
I wanted to be a fully formed antitrust lawyer.
Got it. So you knew that it was rounding out your skills in
Yeah,
this domain that you had already understood that you cared about. That makes sense.
totally. And I'll tell you the most important bit of advice I got that I routinely tell people now. There's this thing that happens where you chase the positive affirmation, right? But it's like junk food, actually, especially when you're younger in your career, right? Or it's like
Mm.
early days when you're starting something. And I get it. It feels good. You sort of continue doing that thing, like in search of praise, but it's actually really dangerous.
Mm.
And so the way to counter that is to build up this internal governor of like when you've actually done a good job. And the reason for that is twofold. The first is that it's protective. You will encounter people, unfortunately, who are either curmudgeonly, just maybe harmful, maybe put you down, maybe make you feel poorly, even when you have done great work.
Hmm.
And if you know whether you have actually done a good job, it will insulate you, right? And you will not judge your self worth, your professional value on the viewpoints of people whose opinions you should not take to heart. The second thing is that there may be times when maybe you phone it in a little bit, like you don't really put your whole self into something and you meet people who just dole out praise. Everything is amazing. Everything is wonderful. Right. And those people just say that to everyone. Right. And you should not get too high based on the praises of those people.
Totally.
Right. And that's why you have to become a subject matter expert.
You have to have your own
Right.
view.
Like for yourself.
I
Right.
mean, it's funny. I see a lot of parallels here to things in tech and business. The people who like read the blogs and accept whatever they read, end up solving for the wrong thing because they just don't have their own opinions about stuff. And it does require real maturity to have your own opinion because the early opinions that I had early in my career, they were just kind of dopey. and simplistic because I just hadn't tested them enough. And, or there were like obvious flaws that I wouldn't learn unless I tried to have my own opinions. But then I did learn. The other thing that I think is interesting there is this kind of like almost like sugar of like the cheap calories
Yep.
of praise. And a lot of it is in the personality of the giver, which is to say, like in statistics, there's the concept of Z scoring, where you adjust the mean for something based on what you know. And like I often think about it when I'm doing a reference on somebody, because I'll call somebody up and ask them, what do you think of such and such? And the answer has to be interpreted relative to what I know about the refer. Meaning, if I
Yep.
call a stranger and they say this person's awesome, I actually have no idea. Do they say everybody's awesome? Or is that a
Right.
1 in a million? And whereas, like, for me, if I say somebody's really great, I can be very enthusiastic. Like I tend to go to extremes pretty easily.
Hmm.
Whereas, a lot of people operate in a very narrow range. The best person they ever worked with is like, yeah, they weren't bad. And the worst person they, ever worked with was like, well, I had some complaints. And so, you just have to know the personality of the person. The other thing that I think can affect that is culture of the workplace. And
Yep.
so different workplaces have different cultures on these, I think it varies by demographics. And so one of the things I wanted to pick up on is like, obviously I'm a man and have worked in environments that have been led by men and environments that have been led by women. My mom was a nonprofit executive, so I was used to seeing women in leadership roles. But I've heard women say that when they're surrounded by, well, when there's a woman or some more women in the workplace, they can't always reliably depend on them to advance them as a woman, because of they may be just, not operating with that lens, or they've made accusations that some women are cutting at other women. But it sounds like you had this environment where you felt very supported by a team of all women leaders. And I'm just curious, to what do you attribute that? Was it their personalities as individuals? Like that doesn't seem like a fact that always
Yeah.
follows from the gender of the boss. And again, I say this as a man, and so what do I know? But I'm just curious how it played out for you in that particular context.
In my experience, the personality of the boss matters a lot more than any particular like demographic or identity sort of like group.
Yeah, like the individual matters more than the averages about their group, of course.
Totally. And it's really, again, I don't know if it's, there's something about government or the antitrust division in particular, because again, that's where I spent the lion's share of my career. But I have worked with very, very different personalities over the course of my career and people with very, very different worldviews. And I have had positive experiences and opportunities to advance and succeed under all of them. And I'm grateful for that. And think about that in terms of like the type of workplace that I want to set up, in terms of
Hmm.
the type of institution that I tried very hard to lead when I was at DOJ. It is fascinating, like what people's experiences of the workplace are.
And so you've got this powerful why orientation, which is about the purpose of what the organization is doing. That can do, of course, a lot of the work. My guess is there are certain things that you also picked up along the way about the how. And so I'm
Yeah.
curious if there were any turning points, moments you remember as your career unfolded where you're like, oh, this is when I picked up this piece of how to be a good lawyer or was recognized. Sometimes it's about how you're seen and telling a story about yourself. And so what were some of those turning points for you?
Yeah. I think once you figure out how to put together a great team, you realize just how much more of yourself you can scale, right? So much of the early part of being a lawyer is building up your own skill and value, right? Like learning the law, learning your craft in the deposition setting and putting together great memos and figuring out a power of persuasion, but then adding someone like a Susan, who is an incredible economist, and then adding your strategist, right? Or someone who's really great at computer science, right? And then adding your technologist, right? And then adding your, I don't know, your health science experts, right? And then building out a team that helps you really understand the dynamics of a market, right, helps you be really effective at, the investigation that you're doing. These different competencies that are going to help us, like it's torque, right? It's
That
just
makes sense. It
moving
sort of helps
faster.
build the potential energy. It sounds like that is some muscle memory from when you brought in those others in past environments. Was there a moment when you felt your confidence jump up as an attorney where you were like, I didn't know that I could do this, but now I can do this? And again, you were modest earlier in your description of whether you feel like a fully fledged attorney yet. But there must be some moments along the way where at least some skill or capacity, you felt like, I didn't know if I had it, but now I got it. Now I can cross examine that person until they bleed. I don't know.
The first time I worked on a no poaching investigation, I called up the companies to say, "We're opening this investigation. I think you've done X." It was intense. It was a very, like, "How dare you?" kind of exchange, and I was on the receiving end of that. Like, they were not happy. We rolled up our sleeves, did the investigative work. Eventually, a company flipped. They ultimately decided to cooperate with
I
the
see.
government and acknowledged
And rat
that we were
out their
correct.
co-agreeers on this no poach agreement.
Yes. And the day they came in with a binder of documents to show us about their conspiracy, I felt like my skill as an investigator and as a tactician was affirmed.
Yeah, I play chess very poorly, but like what that feels like to me is the moment in chess where you start to sense that you're winning and then the other person realizes it and they just resign.
It felt that way. And so when you start like working on their judgment and then you can go tell another company, not only do I believe you violated the law, but I have a company that's going to cooperate against you,
Yeah, totally.
that's a game changer.
And so what was it? Let's drill into that because I think those stories are so valuable for learning. And I just want a few more minutes before we, move to
Yeah.
zooming out to the system on your career. What do you think it was in that case that you discovered in the investigation or did during the investigation or communicated? What was it that made that company flip?
We were not going to roll over. They knew we were not going to go away.
Well, but okay, but I'm going to push a little harder on that because that
Yeah.
you knew that from the beginning. How, at what point did they come to understand that?
We issued a subpoena that was quite expansive for
So
documents.
sort of show of force a little bit.
There was a show of force, and then there were the deposition notices. So they knew that they were going to have to sit for depositions. Again, sworn testimony under penalty of perjury. That was powerful. In addition, I think it was getting around to the industry that the Justice Department was calling around, right?
So
And
there's some
so,
surround sound that you had started to do it.
right. I also think there's some reputation around this, right? We had just spent a long time investigating a merger. And so I think our approach to that merger, being a straight shooter, building up some rapport with the lawyers so that they understood, we were not like take off your shoe and beat the table kinds of like crazy people, and building some credibility, I think helps,
Makes sense.
right? Like the second time around. And you're not always going to have that.
Yeah, I love that. And I think that is incredibly powerful. Okay, so you knew then that you had that. And I guess, another way somebody could have taken the question I asked about when you had the confidence was that it was about their inner life. And so I just want to ask you to reflect for a minute on the inner life of advancing in your career.
Wow, that's a big question.
Mhm.
It's so hard to separate that question from like the big, lofty, sort of like gratitude to the country, the showing up to DOJ, wanting to be someone who's worthy of the institution and someone wanting to give back. And,
Yeah, us civics
you
kids are
know,
quite earnest. My wife is like this too, where she's like
yeah,
she was into civics and now she like wants democracy to work right. Like she wants it to work
totally.
more like the way it says on the tin. So I get that. I hear some
Yeah,
solemnity is a little bit of too sad a word maybe, but some gravitas. There are different
totally.
ways to respond to that. One way to respond to that is look at me, I'm fucking at DOJ. The flag flies outside and I walk in and I have a badge. Another way of responding to that is imposter syndrome of like I'll find out that I actually don't know what I'm doing here. And I used to like cry many nights after my city hall job because I was just like, I really don't know what I'm doing all day long. And at some point, they will discover that. And so there are lots of valid inner responses to that elevated pride. And I'm just curious what yours were.
No, 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 no. It was actually the opposite of
Okay.
that. I mean, I had come from a law firm that represented really big companies, and so I knew the standards of law practice for elite companies. And, when you have deep resources to hire as many law firms as you want to represent you, and when the CEO has four lawyers representing him in a deposition in front of DOJ, what that standard is. And it really pissed me off that the average person did not have that, right? The Justice Department is supposed to stand in for that person. And
Mm.
it was not clear to me, especially after some of the really horrendous behavior around the financial crisis, that the average person had that in our democratic institutions. And so when I went to DOJ, I remember sort of wondering, like, okay, well, what is this all about? What are the cases that we're investigating? What are we investing resources in? What kinds of questions are people asking? And again, there was incredible like esprit de corps. We had great leaders, right? This is the end of the Obama administration. Like it was a really happy time to be in government, but I did have a sense that government can and should be doing more.
Hmm.
Right, and by the time I had a chance to help lead the antitrust division, it was my expectation that we would be asking harder questions and reprising the role of the people's lawyers, right? So it wasn't imposter syndrome. I mean, just to be clear, it was I know what the standards were for me when I was representing insert your favorite Fortune 100 company, and I
Hmm.
think the person in Wisconsin should have that too.
Meaning you felt like you knew a quality bar and you had the confidence of bringing your awareness of that quality bar to this new setting where your new
Yeah.
client, the typical person in Wisconsin, would have the same caliber of service. Were there moments of tremendous self-doubt at any point along the way?
Totally, it's hard. It's hard to stare down deeply resourced
Yeah, I mean, you've said
companies.
before, like, one of your like opponents, I don't know if opponent is the right word, counterparties, what, not counterparties, not the right word either. The company on the other side, that their legal division was like multiple times the size of the entire legal crew you had working on a case. So there is a bit of a
Totally.
David and Goliath thing from your perspective. I imagine from theirs too, because you have the power of the government and they do not. And
Yeah.
so how does that power dynamic feel in practice?
It can be really daunting, especially if, you consider that for a long time, the government was caged, right? And the powers that it could bring to bear against very large corporations, right? Like there were consequences or could be consequences. If you lost a case, my gosh, right? Like that could be career ending for
Yeah,
prosecutors, right?
got
Like
it.
there were certain companies that, people might have thought were untouchable, right? And that
Yeah.
was not true when we were in charge, but that was a different time.
That makes total sense. And okay, so what are you working on getting better at now?
As a recovering lawyer,
Huh?
I am trying to learn more about, I don't know, machine learning.
New topic areas. Yeah.
Yeah, it's humbling. Every week, like by Friday night, I feel like a truck has hit me. So I have a 4-year-old and she is amazing, but she started PK3 last year. And I remember going to the orientation, and her teacher said, learning is it's exhausting for them. And so some
Mm,
days they're going to
I
come
love that.
home and they're just going to be cranky and they're going to start crying and then they're just going to go
They
to
had a busy
sleep.
day at the office.
Yeah, and I I totally get that. Like, my 4-year-old and I have never been closer because by Friday night, we are ready to go to sleep at, like,
Uh-huh.
8 p.m.,
Totally.
and that's what,
Oh, I
building
love
a
that.
company feels like.
Yeah, there's like a stamina aspect of all this. So, just one note that brings up for you: you describe yourself as a recovering lawyer. You're obviously still a lawyer by background
Yeah,
and by capabilities, even if you're not practicing as a lawyer in the context of
yeah,
your current role exactly. Professional reputations tend to operate, they can be very valuable or very harmful in one's
yeah.
career. And they tend to operate, unless somebody's famous, which you have enough public awareness of you that you have some public reputation, but they operate a lot within communities. How do professional reputations work for litigators or in the law? Because it seems like the kind of thing where like many of your colleagues are also people you're on the other side from, or they remember everything and may use it against you. And so I'm curious how professional reputation operates in that community.
They matter hugely, and you should protect your reputation. You should have high integrity. It's very important that people can count on the representations that you make. And in a profession where your clients count on you to make the best argument on their behalf, it can be a tough line separating the lawyer from the company,
Well, so okay, so here's
you
that's
know?
interesting because what you just described there is protecting your reputation,
Mhm.
implying that the main reputational dynamic is threats on your reputation for some untoward or mildly objectionable or even just suboptimal behavior, as opposed to in a lot of other domains, the word somebody might use would be building your reputation. I want to become known for being great at something. And
Yeah.
so, yeah, tell us a little bit more about how that operates. Like, is it a
Yeah.
fear of doing something that gets you dinged?
Yeah. I mean, let's presume that you should build a reputation
Yep.
such that, people hire you to do the job of an antitrust lawyer, get the merger through, go to the government, lead an important investigation, do the different things, in an antitrust context. The
Yes.
job of a lawyer is, in my opinion, secondary to the fact that the day you get licensed, you are an officer of the court. And it comes with a set of responsibilities. So when you get sworn, you, you know, sort of become a member of the bar, which, it's not just like a guild, it's like there are standards of decorum. It is
Hmm.
the lawyer's job to be truthful. There are all of these obligations about like moral, upstanding behavior that the lawyer must engage in, right? Just like in your regular life.
Sort of like being a doctor in that way, where there's an ethical standard that applies for the entirety of your life as you accept that responsibility. Is that what you're saying?
Yeah. And that's why I say you must protect your reputation. Because again, before you have taken on a single case, you've already accepted these obligations to behave well. And again, as a condition of your licensing, you've passed character and fitness requirements and like someone has already looked into your background as a condition of your licensing. So, there's some standard like on day 1.
Sure. And at one point, I think I remember somewhere that you were sued personally, or KKR or somebody sued you. Is that the kind of thing that is like a bad reputation moment? Is it like a doctor in malpractice, or is that more like no, all's fair in love and war? You're going after them, and they're going after you.
Yeah, KK. So, by way of background,
Uh huh.
one of the cases that I filed when I was acting head of the antitrust division was a lawsuit against a private equity firm called KKR. And the theory of that lawsuit was that
By the way, the business
there
person in me
were,
is like a private equity firm called KKR is a little bit like I don't know, like a sports team like called the Yankees or something like that. But yeah, keep
yeah.
going.
um, And the theory of that lawsuit, the allegations anyway, were that they did a bunch of transactions. When you do transactions that are valued above a certain threshold, You have to file a notification with the government, and that notification requires you to file a series of documents. And the government alleged that they doctored some documents, that there were some things that they failed to file, some transactions they didn't notify at all, and detailed this in a complaint. KKR shortly after filed something essentially saying, this is unconstitutional. Like the law that the government alleges that we violated is unconstitutional. The penalty violates the Eighth Amendment and certain other claims. But you cannot actually sue the United States as such. And so you have to sue the official sort of
I see.
filing the case.
Got it. So you were being sued in the capacity of your role as opposed to Doha as human being sued.
Yeah.
Okay, but I do want to ask something maybe potentially, well, I want to ask something about Doha as human. Okay, the thing that I want to raise is a conversation that I don't personally obviously can't relate to because I haven't experienced it, which is race. And what did it feel like? I mean, I know you've talked about the fact, and maybe I looked up some research on it, that shockingly small percentage of litigators who are Black, and you're also an immigrant. And I'm just curious, what role, if any, do you feel that played in your career and professional development?
Yeah. Um, it seems like an impossibly sad fact that in 2000, I don't know, I guess 21 or so, there hadn't been very many Black officials at the antitrust division who either served in the top job or the number two slot. That being said, it's not going to get better until it gets better. And frankly, you know, seeing is believing. And I think that antitrust in particular is undergoing a moment of very significant generational change. And I think the more that young people identify it with a sort of justice movement and an
Mm.
opportunity to make markets more accessible and fairer for regular people, I think you will just see the profession start to look a little more like the country.
It's interesting that you identify that as being anchored in antitrust as opposed to, say, the legal profession or litigation as a whole. I mean, I know that we saw that fewer than 3% in 2020, fewer than 3% of the lawyers in the antitrust division were Black. And I
Mm.
just have no idea how different that is from other things. So I'm just curious, why locate the issue there as opposed to somewhere else?
Yeah, I mean, I just sort of tend to speak to what I know.
Yeah, okay, fair
I
enough.
think that there are, pretty well observed, well documented, disparities in a lot of like elite professions, in terms of like representation around like racial and gender lines. And I just sort of can't speak to the
Yeah,
causes
sure.
generally.
Yeah, and by the way, I'm
Um,
not necessarily asking you to. I'm more asking about your personal experiences. So
yeah.
please keep going.
Yeah, totally. I mean, it didn't really escape my notice, when I started in antitrust that there weren't a lot of people, who look like me in the profession. That being said, again, sort of going back to prior themes, like it's sort of the experience of the immigrant kid too, right? Like I was born in Sudan and, even in a room where even like the vast majority of people, maybe Black Americans, having not been born here is something that can make me different than people in that room. And so I think that sort of the racial composition of the bar is just not something that dissuaded me from pursuing a career in antitrust. And again, it's an elite practice even among legal specialties, right? It's an issue that people tend to run into, when representing frankly a small subset of companies, right, that face antitrust issues. But even that is changing, right? The language of antitrust is changing as people think about, the role of monopolies and oligopolies and coordinated conduct affecting the market opportunities of working people, of working families, of farmers, of nurses, of teachers, of entrepreneurs. You know, I think Americans become more interested in antitrust, and it sort of goes back to its roots, which was a legal vehicle that was championed by farmers and producers as a means of, cementing fair dealing as the rule of markets,
Yeah, I mean,
right?
look, we have a long tradition of justice with things like civil rights, but we don't
Totally.
necessarily think of antitrust in the same boat. And so you're putting it squarely in that domain. And my understanding is that a lot of young lawyers are now really into the idea of doing this, in part because of what they were inspired. And I don't know how much of that is that they like understand the substance of the cause. I'm not saying they don't, versus they just see somebody trying to try hard at something and be vigorous and ambitious and, and then see themselves in people like you and, Lena Khan. And, I know like others in the FTC who seemed inspiring to young lawyers, and Jonathan and et cetera. And it makes sense as a lens to have had personally on this. So I want to start asking some questions about the system before we wrap and
Yeah.
do a whole 6-hour podcast on the legal system, which we're not going to do. It's going to mostly be in the context of you and your career. But anything else you want to say about race or any of the other career matters before we go on to the system a little bit more?
Yeah. I mean, 1 week before the election, I gave an entire speech about antitrust and economic liberty. And it's actually getting ready to come out as an entire article in the Fordham Law Review. And again, it was based on this observation that I had about Democrats, because again, I was an appointee in a Democratic administration where, we just did not seem to have a position on the economics, and yet had been the party championing civil rights and these social liberties. But it had been my observation that that was a really incomplete notion of the full participation in our republic. And so I went back into the history books because that's what I do when I'm unsure about a concept. And what I found was a really nice foundation to make the case that antitrust and some of the civil liberties that we hold dear were really born under the same star.
Mm,
And I gave an entire speech, the thesis of which was that full participation in our democracy really requires robust social, civil, and economic rights. And the Supreme Court seemed to recognize that a long time ago, right? Justice Thurgood Marshall writes in a Supreme Court case called Topco, the facts of which don't really matter. I mean, it's an antitrust case,
okay. Yeah.
but he says that the antitrust laws are the Magna Carta of economic liberty, and that they're as important to our economic rights as the Bill of Rights is to our civil rights. And that's a big deal, especially for someone like Thurgood Marshall, right, who knows something about civil rights, right? And going back into the history books, what I saw was that some of the biggest champions of civil rights were actually huge champions of the antitrust laws, and that vice versa was actually true as well.
And I think it goes to, civil rights leaders like Martin Luther King, who were as, if you look at his body of writings, it's as much about economics and helping people who are struggling economically as it is about race per se.
Totally. Totally. And he and Bayard Rustin just sort of understood that, like, the Civil Rights Act of 1964, those civil liberties were really won, I think he says, like, at a discount without economic rights. And so conservatives often say that, like, the Second Amendment is the right that guarantees all others. And so I came away from that research kind of wondering if economic rights are the backstop for a lot of other rights. And again, it's sort of borne out in the writings of a lot of Reconstruction scholars from Frederick Douglass to Abraham Lincoln, right? This notion that our full participation in the Republic is really incomplete without deep roots and an economic liberty. And so I just, again, I came away from that
The
thinking,
centrality of economic liberty.
yes, we need a full formed notion of economic liberty. And again, all of us with a progressive heart, we need to find vehicles in the market to achieve all of these ideals. Is very, very important.
Yeah, I love that. And I feel like it sees this systemic take where, it's a lot of conservative economists, honestly, and conservative legal scholars who did that tie between economic incentives and markets and the law and vice versa, and really opened my eyes, to it. But of course, you described the tradition of it in, justice related thinking and fields. So let me ask this about the system. Given that goal, how well does the system achieve the goal of providing that kind of economic justice?
I think it's out of whack.
So not
I think
that
it's out of
well.
whack. Not that well. Yeah, we have work to do. We have work to do. And I say this as someone who, again, has been extraordinarily fortunate. I have found opportunities. I've been so lucky in life. That is not true of every person in this country.
Sure. I feel the same way, of course. The system served me very well, but I had lots of personal advantages too. And
Yeah.
so I would love for it to serve others as well as it served me.
Totally, totally. And I should say, I am one of the things that made me very excited to meet you, Roy, was when I got to, start working on the labor initiative at DOJ after I was working for Macon. It wasn't just the no poach and wage fixing stuff. When I started thinking about monopsony, I was reading all of this future of work stuff. And I was like, who's this guy, Roy Bahat? This is so interesting.
Hmm,
And so that's actually how I first started reading about your stuff. So thank you for your work
you.
in this space. It's
Oh,
really
that's
exciting.
awesome.
Yeah, look, the system is not, it's not working well. I don't think my field is a panacea. I think we need better fiscal policy and tax policy and childcare policy and trade policy. And there's the enormity of the problem
Not to
is
mention, by the way,
almost
I'll just say, like, when I asked you about the justice system, I think that we in the private sector certainly have, like, it's not just policy. Our actions can shape collectively and individually how this all unfolds too. I appreciate you saying
totally.
that. I want to broaden it even further, but sorry, keep going.
Yeah, totally, totally. And I'm again glad there are people like Susan Athey who are routinely called upon to think about very big picture issues like technological change and insert your favorite big issue like trade, the future of work, etc. But in terms of the your question narrowly is like the justice system, like how is it working
Or
well?
the goal that you described, or in general, but just sort of given that we have this desire to have economic liberty for people that many of us share, how well does the justice system effectuate that?
I mean, not particularly well. I mean, when we got in, right, we were focused on trying to open up markets and make sure that they are vibrant and conducive to competition and fair dealing. But this was after they had sort of atrophied for a long time, right? And I'm not foolish enough to think that markets are sort of dead without government intervention. Maybe some of them will be okay, but I think there are some missed opportunities, the true consequences of which will not be seen until much further in the future. I think we are seeing the federal government take huge steps back. I am alarmed,
Hmm.
alarmed by how invasive the federal government has been in the last couple of years, right? Like the sort of free enterprise system, as I have known it for most of my life, seems to be teetering in ways that shock me. And it's not accruing to the benefit of ordinary people, right? So I am alarmed. I hope there are big thinkers who are thinking about policy interventions that will be needed in the future because I think it's getting worse, not better.
Yeah, I mean, it's of course, you raise that the government's intervention in markets in other ways or with companies is deeply related to how the justice system works. I want to talk about labor in a second, but the narrow observation I'll just make from the business community is it has always felt to me in the business community like there were checks and balances mostly at play, which is to say, if you didn't like something that one branch of the government did, you could take it to the courts and you would be,
Right.
if not reliably guaranteed a fair hearing, at least often enough with enough resources put at it, dot, dot, dot. And I think there is some declining confidence in that in the business community. And,
Right.
we need confidence in these institutions for the startups that one builds that serve them to work, for everything to work. And by the way, I think that a lot of the critique of institutions, especially government, was because government's failing to deliver for people for a long time. So of course you're going to be skeptical. And some of it is this present consequence. But, there are ways in which I think that there are underlying assumptions that have been there for a long time. So I'm going to give you one of my most tricky ones. So you and I, we both care about people getting paid more at work. Unions are one way that in certain occupations, some people have done much better for themselves over time and that they've elevated the standards historically for people throughout the society and economy. You know how you were saying that there's that no poach agreement that you prosecuted? You know, seems perfectly legal to me for if a worker wants to unionize their workplace, for big unions to call each other and say, you work with them, not us, and to agree on whether or not that is okay, not to compete with each other. That's a behavior that if it were the private sector would be, I think, illegal. And I'm just curious, and obviously, I know I'm stepping in sensitive terrain here, but do you have thoughts on whether it's
You
okay?
mean like for unions to say, you take that group of people and we'll take this
Yeah,
other group
unions
of
routinely
people?
call each other and say, you don't work with them. We are going to work with them, even though it's two different unions. And the people who might be trying to unionize might prefer the union that got kicked out. And
Interesting.
by the way, I'll just stop as you think about it for a second and say, this is a way in which I think, our teams and systems can sometimes get in the way. Like unions are an enormously consequential economic force. They represent, just under 10% of the workforce and around, if I looked at the numbers last time, 6% of the private workforce. And they are allowed by law to agree with each other on who to serve.
Yeah, I totally hear you. I will just say antitrust law is subordinated to federal labor law.
Oh, interesting. So labor law comes first.
Yes, such as it is, right? Labor law has atrophied, of course, and there's been a down reading of that law. But I hear you. I think unions provide extraordinarily important labor protections. If we got to the point where, our biggest concern was sort of choice of union, that would be an extraordinary day. Truly,
Yeah.
I've never seen that problem in my lifetime, but you know, may we all get there.
It happens. And I mean, look, there's a case to be made. I'll just say, if I put my economist hat on, look, and I say this as a person who is an ally to labor unions, there are arguments both ways about the practice. I'm not condemning the practice, but what a person would say about it. If you said that same thing was happening in the business world, you'd say, well, of course, we don't reach the place where people have to compete between these two because they haven't been competing for so long. They haven't innovated sufficiently. Competition has a beneficial effect on entries in a market. Now, of course, you can make the case that, well, even if you're a monopolist, you have to compete with the person's other alternatives for time. Or, in the case of a labor union, the competition might be seen as the company. I don't think that's the right way to look at it. To me, what's delicious about these questions, and one of the reasons I wanted to take us there, is that there is a way in which we have all these fundamental assumptions baked in to how the system works. And you reach a certain point in your career where, you do have not just involvement in the system, but some custody over the system. And that's a
Totally.
career moment too. And so, okay, let me ask you about a different thing, just a couple more quick ones, or maybe not quick, but on the system, which is, does tech work in the law?
Yeah.
Should it? How should it?
Totally. So I am very warm to Cory Doctorow's view about.
Fiction writer and essayist as well.
Yeah. So, again, just to back up, so I think Corey is brilliant. He's also really funny. I think he's been appropriately critical of some tech, but I also think there's more pragmatism than not in a lot of what he's saying. I think that tech is a tool. I think that some concerns around like tech and AI are more to do with the implementation of technology than the technology itself. And I think that tech can be an equalizer and a tool for raising the standards for the legal profession. Let me say more about what I mean about that. I'm thinking about law practice that is small litigation shops, people who want to be standard bearers in their communities, 10 and 12 and 15-person boutiques that want to take on cases that matter, and don't want to grow into 1,000 person law firms. More power to the firms that are that, but not everyone wants to be that. They should nonetheless be able to take on these cases. Like in the antitrust space, technology can be a tremendous source of scale for those companies. And so I think that's great. I think often when we hear about tech and AI in professional settings, a new technology has rolled out, and the first thing you hear is, here's, insert your favorite AI technology or something. And a hospital says, great, we're going to lay off 50% of the radiologists. And it's like, okay, that has terrified people. The radiologists are against it. And no one feels good about the system. But here's like the hospital CEO thinking about how to make the hospital like more profitable and has said this. In reality, the better version of this like wonderful technology story is Americans are dying of this awful cancer. Here's an AI that is going to take us from capturing 95% of the tumors to 99% of the tumors. You know, your radiologist is remaining in the loop, or, this nurse is going to be able to catch some of this such that you can talk to your radiologist about it. That is a good news story, right? Like that
Hmm.
is a tech for good story. But again, that has nothing to do with like the tech itself. It is the youth story, right? Like that is a business decision about how to use the technology. And so we are thinking about one, humans in the loop, raising standards. We are thinking about how to use technology as a great equalizer and not, these horror stories that are just like littered about, newspapers and the media that make people more nervous than not. I think this is just like an absolute own goal.
Well, yes. And I think that what's interesting, I was just in a group chat where people were talking about this, is, on some level, the companies are being honest about what they see the consequences as being, talking about what the effects are going to be. Like there might be job loss, for example. They are disclosing things that they believe to be true that may or may not be in their self interest. And I think that there is an own goal around, adoption is not a obviously good thing in all circumstances, in all occupations, in all lines of work. And I think that there's a way in which tech companies can be very absolutist about, if we have some tech, therefore all tech good, instead of being discerning. And discernment, I mean, you said it about yourself in the legal profession, applying judgment to ourselves as the tech industry, I think can be incredibly powerful.
Yeah.
I also, you've said before, you gave this speech where you said norms are not going to save us. And so it occurs to me now, like, what I just said is sort of calling for a norm. I guess the implication in there is policy can save us, sort of the laws as written, or what is the implication in terms of what can save us?
Yeah, I think the implication there is we can actually just do stuff, right? Going back to your labor union example, I think one reason why fights over policy and, changing our laws feel so consequential is because we don't do it often enough. And
Mm.
so every time we gear up to change
It's a
something, it's like,
massive
my
thing.
God, yeah, are we going to live with this for 100 years?
Yeah. When was the Sherman Act passed? 1890?
1890.
Yeah.
1890. Now, I happen to love the Sherman Act, right? Like,
Sure, sure. I mean, look, I love the US Constitution. It was written a long time ago as well, you know?
but
Yeah.
we've at least amended it like a
Yeah,
lot
totally.
since then. But, you know, my critique on the norms was a critique actually of the Biden administration, right?
Hmm.
My critique was that, we had held on to norms as a justification for not doing things that the American people, in fact, demanded. And I think that Republicans often are better at just doing stuff, right? And we need to just be less polite and pearl clutching
Yeah.
as Dems and just do the thing. Do the thing.
Yeah. Well, I will just say, as a registered independent, I've worked for Republicans, I've supported Republicans, but in recent years, less so. Let's just say, or not at all, or on many issues, actually, yes, but maybe not necessarily candidates per se. I feel like there's a incumbent attacker story here about who is perceived to hold the power. And, there's a way that I think a lot of the country perceives that people who went to schools like the ones you and I went to have held the power for too
Mm.
long or at their detriment. And that is as much overlaid on the political partisan nature of it as anything else. And, what I hear you doing is picking a norm that you see others have as having had that you want to practice, which is go for it and just do it. And as an early stage startup investor, I think that is a thing that, of course, I commend. And the other thing that I commend, just to say, and maybe this is something we can sort of start to close with, is I don't know, the interpersonal or emotional nature of how we do that. I mean, you said earlier something that really surprised me, which is you said, I don't see my opponents in the courtroom as bad guys. And, the speech that you encouraged me to read about being a federal prosecutor said, and this is just a quote I thought was beautiful: the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims. And so I guess, my question as we reflect is, what's the role in the system for that kind of kindness?
Oh my gosh. There's a huge role for that, right? Kindness does not mean letting just like wanton law breaking just like pass, right? Without incident. I think what it means is understanding the consequences of every enforcement decision, right?
Mm.
It means seeing all sides of every issue. It means understanding the consequences of not filing an enforcement action. In some cases, it means understanding the consequences of a system where little companies are routinely prosecuted and law breaking by companies that have much more expansive like impact on the economy go unprosecuted. But it also means understanding that, there are lots of documents that frankly read horribly after the fact. There are lots of times when each of us has been the beneficiary of mercy or has had an opportunity to explain something, right? Or you've been allowed to provide context. It's like providing a totality of circumstances for
Yeah. I mean, I'm
something,
just going to go back
right?
to the word that isn't quite right for this, which is empathy. But the idea that's more right, I can't quite find the word, is something like being able to see from multiple perspectives. And, your
Totally.
history teacher background
Totally.
feels like it helps to do that. Your immigrant background feels like it helps to do that. And so I guess I'm getting a little bit of a tour de force in seeing how that turns into, well, it's not just antitrust, it's all these other forms of policy, and it's the norms in the private sector, and that you can apply that to everything from understanding Sherman to understanding Google or whoever else.
Yeah.
Anything else you want to say about the system before I ask you one last question?
Well, the last thing I'll say about the system is look, the bones are good. We get out of whack from time to time, but the good news is that we have the tooling to make it better. We just have to decide to make it better. And I think that my orientation is always to make things better for the average person. that's what I enjoyed doing when I was in office. I liked talking to
Yeah.
regular people, about, you know, PBMs
PBM is a
and
pharmacy benefit manager, like how they get
yes,
their pharmaceutical benefits.
insane. And then the founders who were doing like defense tech and trying to like catch up to like the big incumbent defense contractors, right? Like they're just people doing interesting things, chasing interesting opportunities all the time.
Yeah.
And I don't know, I have a lot of interest in the average American.
Yeah. I mean, I think it's powerful. And I know, one of your indirect colleagues on the FTC wrote this piece, Alvaro Bedoya, about how he became a populist, which was really, to me, a piece that was full of stories about how he came to understand the plight of Americans in different circumstances.
Yeah.
And again, broadening perspective. Okay. Last one, Doha. While we're not in the advice business here, one person who you are most capable, arguably, of giving advice to is past Doha. If you went back to past Doha, when would you go to her and what would you tell her?
Oh my gosh. Okay, past Doha. Hmm. Oh, this is so hard.
By design.
Well, there isn't a particular moment that I can talk about, but there are many challenging moments I can recall where the pressure was extremely high. And I chose to have a backbone of steel, but it was hard because you sort of wonder, am I drawing the right judgment?
Resolute determination and action while holding uncertainty about correctness.
Yeah.
It's a trait of the entrepreneur, and how
Yeah.
can you authentically do conviction while we all know all judgments are risks? They're all,
Yeah.
it might work this way and not. So I think that's even just, by the way, awareness of the paradox, I think is its own powerful thing.
Yeah.
And I appreciate you not
Totally.
giving a pat answer. Like I like ending on a, hey, I'm thinking about this more because, I remember Mike Bloomberg once said something to me where he was saying, when I see Nobel Prize winners, they're still asking questions. Actually, my former boss, Dan Doctoroff, who is suffering from ALS,
Mm,
a few months ago, I was
sorry.
talking with him and he was like, how can I learn more about AI? It's like, brother, like the fact you're still adding learning it's powerful. And so the fact that you are still wondering about questions to me means others can meet you along the journey, not as a finished product with all the success we see you as having, but as a work in progress, as we all are.
You are very kind, Roy. Thank you very much.
Well, this is a great joy. Thank you for the stamina to be here and to be
Same
continued.
to you.
This Not Advice actually started as a series of hundreds of short answers to people's dilemmas about work. So if you're interested in more, head on over to the website, thisisnotadvice.work, which is a guide based on all those questions and answers, which anyone, including you, can edit. And if you made it this far, I'd love to hear what you thought of this long form version of This Is Not Advice about a whole occupation. And as my coach tells me, your feedback is a gift. I'm Roy Bahat. Thank you for listening.